Hmm. $57. Wait, where is supplementary list? Supplementary list 9 again? Supplementary list is not there. Okay, 57, what do you want? Okay. 57 not likha. The Mr. S.S. Roy, learned standing counsel oh, contempt matter. There's only one respondent. Yes. Okay. Mr. S.S. Roy, learned counsel for the respondent, prays for prays for some time to to get the instruction and to file the affidavit. Prayer is allowed. List this matter on, this is May, right? Today is 11th. So list this matter on, okay, 4th of June, Thursday. 4th of June. Okay. Okay. Hmm. 1-5. You are for the government respondents. IIT. Okay. So you have received your response, received your. Okay. You are Mr. S. Sutradhar. Mr. S. Sutradhar, learned standing counsel for the IIT, submits that although he has received some instructions, but the same is not complete, and he has prayed for some time to get the full instruction and to file an affidavit incorporating the same. Prayer is allowed. List this matter on 8th of June. 9, 9 and 10. So why 9 or 10? Yes. Okay, okay. You want the date to be fixed. I thought 9 and 10. I mean, item number. Okay. So list this matter on 10th of June. That's a long time, huh? You file it. Yes. Mr. Botaku is there for 10? Oh, your only, your matter. Okay. Hmm? I thought he's for respondent side. Acha. Affidavit in reply. You have informed the government side. GA is there. Yes. Okay. Mr. Yes. So on behalf of Mr. S. Botakur, learned counsel for the petitioner submits that they require some time to file their affidavit in reply and has prayed for accommodation. Prayer is allowed. Release this matter on 26th of May. 26th of May. Is it okay, Mr. Botakur? 2 weeks time you get? Not 2 weeks, 1 week. Or you want it in June? Okay, 2nd of June. 2 weeks time you get. One second. Yes, one. This is a vacating application. Mm. Bench what? This is also 2. 2 and 3 together. Mm. Okay, you take time for objection. You are for the petitioner. Acha. Last time you did not receive your application. Acha. Now you have. Acha. Okay. Right. Heard Mr. M. Sharma, learned counsel for the respondent. Respondents. Acha, you are for the petitioner. Okay. I. No, in I, you write, heard Mr. M. Sharma, learned counsel for the applicant. Okay. Uh-huh. Respondent in the IA, you write, in the for the respondent. And Miss P. P. Sinha, learned counsel for the applicant. Yeah, applicant in the IA. Mr. Sharma submits that he requires some time to file the affidavit in opposition. Prayer is allowed. List this matter after 2 weeks. Affidavit in reply. Oh, mm. Require some time to file their objection to the stay vacating application. Prayer is allowed. List this matter. When do you want? Hmm? Last will list this matter on 28th of May. In the writ petition also you write that as prayed for by the learned counsel, list this matter on 28th of May. Mm. Would be well advised to file a reply to the okay, considering the above. Okay, so final opportunity was given. So after some time, you have filed your reply. Okay, there is any change of counsels? Acha, this is item 2, right? Earlier, I think some Mr. R. Majumdar, P. Rai were there. Now you and your senior appears. Okay, after some time. I mean, I don't know what her senior has to say. It's okay if I'll accommodate you. You go wherever. Yes, Mr. Burwa. Hmm. Hmm. I'll just go to the last order. This was in April 25. 1 year has gone. Hmm. So petitioners are working on contractual basis since 2007 and services are not regularized. And you're yet to file your affidavit. Acha, then I think the Uma Devi will come to his rescue. Paragraph 52. If something is pending, so mm, mm. What is the requisite qualification? Mm, mm. PhD. Why the mic is not working properly, Mr. Harikrishna? There's difficulty in hearing. I don't have problems in hearing, I think.
Now. This switch was off.
Oh, okay. Now tell.
And my lord,
Mm,
thereafter, my lord, what happened, my lord? One
mm,
person, my lord, he has completed the PhD degree in the year of 2020.
mm.
And accordingly, my lord, he has been regularized. but
Okay.
we have not been considered at that time since we have not the requisite qualifications. Now we have the requisite qualification.
At that
And
time you did not have, now you have.
Yes,
Now we'll have to look into whether that will be
yes, that is
sufficient.
the case, my lord. As
Okay.
Zago is concerned, my lord. Now, my lord, in the 26, my lord, another case is come out, my lord, in the year of 2004, 2026, the Supreme Court, Modern Singh case.
When is the, what case are fixed?
That case is that, my lord, the regularization who has completed the 10 years of service, having the requisite qualification, without any interrupted, without any adverse remark from the college, and
Are-
research, are entitled to get the regularization. Modern Singh case is says that.
So, ठीक है, but what he wants to go through those division bench orders.
That division bench order is total difference, my lord. They have
Okay,
not
we will
completed
take it
the
up
10
next
years.
week. You go through, maybe he has something
Yes,
to
ma'am.
say.
Fine.
Next week. Okay.
Next,
As prayed for by the learned counsel appearing for the respondent, that he has to go through few judgments passed by the honorable division bench in respect of a similar matter. The instant case is deferred and is fixed to be taken up on 29th is a Friday.
Friday, 28, my lord, handover would be made to dispose of the matter on it.
28
8.
or 26th, Tuesday,
26.
26th of first of June. Okay. You go through properly, okay? Fix this matter on 3rd of June. Huh?
Handover would be made to dispose.
Huh?
Handover would be made to dispose of the matter on.
Endeavor will be, you want it to be incorporated in the order?
Yes,
Okay, endeavor should be made on the said day to dispose of the instant
my lord,
case.
interim order pass earlier shall be.
Interim order is there, but
Yes,
then
basic.
in the last one, in the last occasion, it was not extended.
My lord, interim order.
No.
is there. Interim order.
Mhm.
21, in the year of 2021, my lord, interim was granted, my lord.
But then it was not extended. Maybe it was until it was not
No,
required to be
that-
extended.
My lord, that order is 3/6/2021. Having heard the learned counsel.
Let their services not be disturbed during pendency of this
Yes,
petition.
my lord, this is the,
But then see, after that, it was not extended.
my lord, this is the continuing. This is the continuing order, my lord.
Hmm.
This is not said that the next date or any time period was not.
So not required to be extended
Yes,
again.
ma'am. It is still continuing during the pendency of this petition. That
Mhm.
means is still pending, that is operating, ma'am.
This will be operating
Operating.
till its disposal.
It will.
Mm.
Yeah.
Yes.
What this case is, the other side also considered our prayer.
Ah.
And last occasion, it was supposed to dispose of positive of time could not do. Now, that should be dispose of this case on the basis of their own statement also.
You are ready? What difficulty?
They have
This
had-
seems to say 22 matter. These are very old matters. 22 matter. Let me dispose it off. You have what difficulty you have? I cannot hear. Man, digdar sir. Have switch off the fan. AC दे दीजिए. हाँ. Cannot hear properly. Maybe something is wrong with the mic. Yes.
Due to some personal difficulties, my lordship.
Yes, Mr.
They have filed their affidavit and they have also supported our case.
You are led by, or you will do this
No,
case?
lordship. On behalf of SP Chaudhary, respondent number 3.
Respondent number 3.
Yes, lordship.
They are the main respondent.
Otherwise, oh, you are the main respondent.
Yes,
Respondent number 3.
Yes, lordship.
Otherwise, number of orders, I can see it here.
Any short dated, lordship?
Managing Director of Urban Water Supply.
Yes, lordship.
So, okay, we will take it up day after tomorrow then.
They
Lordship.
have-
Okay. As prayed for by the learned counsel appearing for the respondent, list this matter day after tomorrow, that is 13th of May.
Interim is that was that will call.
Here again, I don't see the interim being
Last-
extended.
Last occasion, Lordship, it was sought for adjournment, so. there was-
Acha,
but
acha.
I read-
Interim order passed earlier shall continue until the next adjournable date.
Lordship, I appear for respond numbers 1 and 2, prominent.
Acha, acha. Mr.
D board.
D. Bora, Learned Counsel appears for respondent 1 and 2.
Item 6.
Yes, Ms. Ghosh.
Lordship, I humbly pray if the matter can be sent for mediation.
Yes, of course. If the
Uh,
other party
once
also
it's
agrees.
sent, but it was not communicated to the parties.
Acha.
Lordship, I'll humbly pray if it's sent for mediation.
What do you have to say
I am the appearing respondent number 5.
on mediation? Okay, let the matter go to mediation. If it
Yes.
fails, it will come back.
Yes, Lordship.
Okay, Mr. Chakraborty. I heard Ms. D. Ghosh, Learned Counsel for the petitioner. Also heard Mr.
Is where
A.H. Bhuya, Learned Counsel for
respondent number 5.
respondent number 5, and Mr. B. Chakraborty
For respondent number 3.
For
Accountant General.
for respondent number 3, and your Mr. Acha, Gompala. So and so for 1, 2, and 4. The parties have agreed that the matter may be sent to mediation. And last time only, I think it was
Yes,
sent for.
Lordship,
What
but
happened?
It was not communicated to the parties, and when the date was fixed for mediation, Lordship, to appear, the already when the letter was received by the petitioner, date has already been left. So this is the
Okay.
reason. Lordship.
Okay, not that order, huh? Kata. On the last occasion, that is on 21/8/2025. This matter has been sent for mediation. And it was also directed that mediation can be completed in offline mode, online mode, or in hybrid mode. Offline mode, online mode, or in hybrid mode. And the date has also been fixed. The date was also fixed. That is on 9/9/2025. And the parties were directed to appear before the High Court Mediation Center on the said date. However, the Learned Counsel for the petitioner submits that information to the parties could not be given, and as such, the parties came to know about the said matter being sent for mediation after the said date of 9/9/2025. And accordingly, the mediation could not be done. The parties have now renewed their prayer for sending the case for mediation. As such, it is directed. Shall I fix
Yes,
a date,
yes.
or mediation center will do?
Lordship may fix a date, and since both the parties are here, all the parties are here,
Okay.
will appear, will inform petitioner, and he can inform the respondent.
So what date you want?
And since both the modes will be there,
Mm.
so online also they can
Mm.
appear through virtual calls. Lordship, feasible to all the parties. Lordship.
Yes, suggest a date where parties can appear before the mediation center. Even online will do.
Yes, Lordship. 21, it's feasible for.
21st of May, this
May,
month.
Lordship. Yes, Lordship.
Yes, Mr. Chakraborty, you don't have much.
Immediate role, we have nothing to.
So respond number 5. Respond number 5 is who actually?
Second.
First 5.
First
Oh.
point.
First 5.
Some pension.
Yes,
Pension.
Lordship. Pension.
Okay. Respond number 5. I'll fix 21st of May as the date. You will inform the parties, okay?
Yes,
Okay.
Lordship.
So, okay, Kolo, accordingly, as such, 21st of May 2026 is fixed as the date for mediation. And it is further directed that the parties will apprise, or that the councils will apprise the parties to appear before the High Court Mediation Center on the said date. And it is also directed that the parties may appear in offline mode or online mode or in hybrid mode. Full stop. Once the mediation is completed, the matter be listed along with the report before this court for further orders. List,
Right.
after that it will come. Yes, Mr. Roy.
I think there's in the mediation, a report from the mediation
Acha.
perhaps has failed, my lord.
Hmm.
So since the matter relates
Hmm.
to pensionary benefits,
Hmm.
otherwise, my lord, the pleadings are complete.
Hmm.
But I pray before lordship may fix the matter another day or for admission, my lord, finally, which can be hard finally. Can it be fixed on 4th of June, my lord?
4th of June.
Lordship.
Why not today?
Today, my lord,
Parties of-
after all, they should be present and then
Mhm.
it's not, lordship may fix it.
Mr. H. Gupta is for respond number 1.
Lordship will fix it on 4th of June, Lordship will finally hear the pensionary benefit.
Your lordship, due to medical emergency, my senior has not come.
Acha, acha. Okay. As agreed to by, oh no, heard Mr. P.K. Roy, learned counsel for the petitioner, and Miss
PR Chaudhary.
P.R. Chaudhary, learned counsel appearing for Mr. H. Gupta, learned counsel for respond number 1. Miss
PR Chaudhary.
PR so-and-so submits that Mr. H. Gupta has some medical emergency and has not been able to come today, and as such has prayed for some time. Prayer is allowed. List this matter on 4th of June, you said.
Lodge.
List this matter on 4th of June 2026, which is agreed to by the learned counsel for the petitioner. List accordingly.
Obligation.
Yes, no one is there.
Mr. Pathak.
Yes, Mr. Pathak. Yes. You are there for the petitioner?
My lord, I have just entered appearance.
Haha.
My lord, otherwise the matter is ready for hearing.
Oh, my lord will fix for hearing then. Pleading is over.
Facts are in a very narrow compass, your lord.
Hmm.
What
If
are-
pleadings are over, what?
Over, my lord.
I can
This will-
dispose it
this-
off.
this will-
Yes, your lord.
Yes,
Hmm.
fix for hearing, my lord.
Yes.
My lord, the issue in a nutshell is
Hmm.
that the Khadi and Handloom Board, your lordship,
Hmm.
their employees were never granted pension, your lordship. So there was,
My lord, my prayer is fix for hearing. This will need some good time. Because
He
he has
said
an,
very short campus.
no, my lord. For him, it is a short compass. But for us, we have to, government will sell out few 100,000.
I'll just give I won't take your lordship the document. I'll just narrate the facts. I'll leave it to your lordship, whether your lordship.
But if you want time, Mr.
My lord has fixed for hearing, my lord. This will need a very good hearing.
Mr. Dhar wants time.
Then may I pray for a date, your lordship?
My lord,
Okay, heard Mr.
I
K.P. Pathak, learned counsel for the petitioner, and Mr. R. Dhar, learned counsel for respondent,
my lord, for 1 and 3.
for respond number 1 and 3, and Mr. P.K. Munir for respond number
4 and 5.
4 and 5. So what about 2? Commissioner, the finance department.
Finance department.
Somebody is appearing for
Final-
finance department.
B. Gogoi, he is here, my lord.
Okay. And Mr. B. Gogoi, learned counsel for finance department. As prayed for by the learned counsel for respondents, list this matter for hearing again. It will come down the list. We will find difficulty.
It will be taken up for admission, your lordship. Disposal of the admission.
List this matter again on when do you want?
My lord.
On 2nd of June, Tuesday.
My lord.
The list will be short on 2nd of June.
It was ordered as 28/11/2025.
Hmm.
Para 5.
Okay, so an instruction had to come from Magad University.
Lordship.
And so who has to do it? Petitioner side?
No, your
No.
lordship, this is by the
Respondents.
Lordship, we have not received the Lordship instruction from the UGC also. UGC stand is also required, Lordship.
Mm.
We have not received, and moreover, Lordship, WBC number 1025 of 2020, filed by the same petitioner, Lordship, it was directed to be tagged with this matter also. But this has not been tagged today, Lordship. And
That order is not there. Where tagging
no,
order is?
it was passed in, it has been passed in the WBC number 1020.
Acha, in that matter.
In that matter.
Mm.
And otherwise, Lordship, the instruction will be very much important. Lordship, a date may be fixed as per the.
So from November instructions, I have not come.
It's very difficult to get, Lordship.
My instruction says, your lordship, they have received it in the office of the director from Magad University.
But
Probably that has
Yeah,
not been
but
communicated to them.
UGC's stand is much more important, Lordship, because we are on UGC's. This is the related to the PhD degree given.
So
by
Magad University instructions you have?
right now I don't have, Lordship. We have
May not be communicated to them, your lordship.
So you get instructions from both the authorities.
Yes, Lordship.
We will then fix it on,
After
it's
3
only
years-
a UGC certificate has to be verified.
But
Oh, I mean the PhD
yes,
certificate.
whether that
So-
PhD is valid or not, that is
Hmm.
not only this case, single case, Lordship. A batch of petitions are just pending. And
Hmm.
even a committee has also been instituted, Lordship, to the unearth this.
Acha, these are all fake
Fake, yes,
certificates
or
according
that
to you.
some
So
time
for
will
your
be
lordship,
required.
we are concerned, your lordship, these are not fakes, your lordship. They
Mm.
have suspected that the procedure have, as per the UGC regulation, has not been followed. That
Acha.
is what they are suspecting, your lordship. That too, is a purely on suspicion, your lordship, this has been done. So this.
Procedure
Yes,
only.
your lordship, you
That
take
can be
instruction and.
condoned or what you said, that can be rectified, that can
Yes,
be.
and this has been pending since 2023, your lordship. See, and it is only, they are saying that instruction is required from UGC. You take steps, bring it, and take a call.
Lordship,
And you are working,
We are working as tutor. We need to be, your lordship,
teacher.
promoted as assistant professor. That's, and since our PhDs are in question, therefore, we have not been upgraded as an assistant professor.
So tutor on fixed pay.
Fixed pay, your lordship. That's what.
See, this has been continuing since long.
That cannot go on
Because-
unending, your lordship.
because of mushroom growth of Lordship, this university, some universities, and the petition, I'm not talking about the particular petitioner. Many of the Lordship we have found, many of them without following procedure, even in 1 year, within 6 months, they also used to get the Lordship, the PhD degree. So
It's
number of,
okay, you bring
That's
it.
why they need to take
Yes.
instruction.
Yeah.
Take a
Yes.
final
And then
so Lordship, we
all
have,
cases will not be same, will
yes,
not be
we have been
similar.
communicating with the UGC also, Lordship. Once we
So you bring it within 1 week.
Lordship, 1 week, it will be difficult, Lordship. Otherwise,
It has been pending since so long.
yes, Lordship.
And UGC instructions were sought for, I think, very long before.
Lordship, 3 weeks time may be granted. I'll communicate, Lordship, so that in the next week we can come with the.
See, 24, since 24.
Yes, Lordship, I understand, Lordship. I have gone through the.
Justice Jammeh's order.
Lordship. 3 weeks time, Lordship, may be given. I'll try to get the Lordship instruction from the.
Not 3 weeks. That will be too long. 2 weeks. I'll fix it on 1st of June.
Lordship.
More than 2 weeks only I'm giving.
1st of June, Lordship.
Almost 3 weeks. I will prepone it. I'll make it 25th of May then.
No, Lordship, in June only, my Lordship.
1st of June.
I'll try to,
You bring it. This is the last chance. We will proceed otherwise.
I'll communicate. Lordship.
Communicate it is not the issue. You have to get the instruction. Communication was
We-
done long back.
No, we have been communicating with the authorities, Lordship, but they are not responding, I suppose, UGC.
You tell them to respond. They have to respond to what you say.
Yes.
It's a court's order. Or I'll call the people here.
UGC, Lordship.
Personal appearance.
No, Lordship, not, I'll try, I'll get the instruction, Lordship.
Heard Mr. S. Bothakur, learned counsel for the petitioner. Oh, learned senior counsel, assisted by Mr. U.S. Bora, learned counsel for the petitioner. And Mr.
AR Tohbilda,
A.R. Tohbilla, learned counsel appearing for
Higher Education Department,
higher education.
Lordship.
For its learned standing counsel for higher education department. Mr. Tohbildar, learned counsel submits that although they have communicated with the University Grant Commission to send the necessary instructions as regards the authenticity of the PhD degree obtained by the petitioners. There are many petitioners.
Lordship.
or
Total
one?
15.
What do you say? Authenticity of the PhD degree obtained by the petitioners from Magad University, Bodh Gaya. However, Mr. Tobila submits that the instructions were awaited. So instructions are awaited, and the same has not been received since long. In view of the same, the Learned Council has prayed for some time. Full stop. It is noticed that on 25/2024, the Director of Higher Education wrote to the UGC seeking certain clarifications, and the same were not received. And as such, 4 weeks' time was given. And thereafter, on 28/11/2025, the same same submission was made that verification could not be obtained from the UGC in spite of the efforts made. And in the said order, it was also reflected on the submission made by the Learned Council that apart from the UGC, instructions should also come from the Magad University. And another 4 weeks' time was taken to do the needful. When the matter is taken up today, the Learned Council, Mr. Tohbildar, submits that neither the instruction from UGC is available nor the instruction from the Magad University. It is seen that the matter has been pending since 2023, and the petitioners are working as tutor on fixed pay since long. In view of the same, a last opportunity is given to the Learned Council appearing for the higher education to get the instruction. Otherwise, this court will be constrained to call for the personal appearance in respect of both the authorities. Personal appearance of the authorities in respect to both the institutions, or what? UGC is not said as an institution. Authorities from both UGC as well as Magad University. List this matter on 1st of June, 2026.
UGC has not been made a party in this matter.
Because your lordship, we are not required
That-
to
but
make the
that-
party
that
because
is the
UGC has
main-
not passed any adverse order against us.
Ah,
But the issue of PhD degree, that everything guidelines is lordship given by the UGC.
supposed to,
You are supposed
Yes.
to do it.
because last time Director of Higher
That-
Education,
Lordship, yes.
that reflected.
Yes.
You get the
Regarding
instruction.
lordship, the personal appearance, lordship has mentioned about UGC
Oh, okay.
also. That may not be because she is not.
Still then we can do,
Yes. yes,
even if they are not
Yes,
parties.
yes, lordship can.
Obliged.
Obliged, lordship.
Mm.
Yes, madam, no affidavit has been filed by the government, madam.
Yes, why?
Sir,
So late?
Lordship will file our affidavit, but Lordship, the petitioner's deceased father, he died in the year 2015, Lordship.
Petitioners?
Yes, Lordship, it's a
Petitioner's father died.
madam.
What you have to got to do with that?
because Lordship, a prolonged delay has occurred, Lordship. And in terms of Debabrata Tiwari judgment, Lordship, after a prolonged delay, either on the part of the petitioner or on the part of the authorities, the compassionate family
So this is a case of compassionate appointment.
Yes, Lordship.
What, somebody has recommended, district or what?
Level committee or malot district recommended malot and state level committee rejected malot.
Why?
As for malot, as because malot the
This is father, have malab, less than 3 years as per.
But that has been settled by the,
And
Settled by
my
the-
lord may come to annexure 13, page 104.
And there, I approach.
the single justice has struck down, division bench has upheld.
Lordship.
Subsequently, my lord, kindly subsequently. my lord,
Lordship,
ask-
her case is not covered by this OM of 2015
Then?
because her father has died before 2015. So this OM will have only prospective application, not retrospective application. Ladyship, that is why the earlier notification before 2015 will apply in her case.
So that clause 1 was not there,
That
right?
is why, your ladyship, in annexure 13104,
Hmm.
the SLC again rejected her case.
What do you say,
This
104?
today again rejected, my lord. Thereafter, I approached before this honorable court, my lord.
Hmm.
The honorable court, my lord, set aside the order and remand back to the state level committee, my lord. And in the meantime, my lord, again, my lord, SLC rejected, stated that, my lord, another ground.
What ground?
Ground, my lord, the father of the petitioner died on, my lord, 6/4/2015.
Hmm.
And office memorandum, my lord, 1/6/2015.
So that is not retrospective, what she said.
Same, my lord. But,
This is not retrospective, right? 15 memorandum?
my lord, Supreme Court judgment,
Prospective.
NC Santos, my lord.
Mm-hmm.
And NC Santos, my lord,
Hmm.
specifically stated that, my lord, at the time of consideration, my lord, not at the time of death, my lord.
Acha. Anyways, yes, memorandum will be applicable at the time of consideration.
Considered
That may be prior to that.
prior to. And, my lord, as per memorandum, my lord,
Hmm.
the earlier scheme already, my lord, cancelled by the government, my lord.
What cancelled by the government?
Government, my lord, kindly see, my lord, page 37, my lord,
Of the petition.
of the petition, my lord. Is the office, subsequent office memorandum, my lord, holding in the field.
This is 1st June.
It is the first paragraph stated, my lord,
This is the memorandum.
office. By this office memorandum, earlier office memorandum already, my lord, the governor of Assam is now pleased to supersede all the earlier office memorandum. The category stated, my lord.
No, when this memorandum was passed, all others gone.
Gone, my lord.
But then when your father died, this was not in force. So the earlier were in force.
Consideration, my lord, subsequent to 1/15, my lord, when the place before.
Any judgments on that? That the
NC Santos I have
the
given, my
Supreme Court
lord.
judgment?
Supreme Court judgment.
Where, what is the paragraph?
Paragraph 19, my lord.
Your ladyship, there are judgments after NC Santosh also. Your ladyship, on the next day, I will produce those judgments and I will also file my affidavit.
Okay, let her file the affidavit. I'll have to be clear on
Done.
this. Because your issue is only on the short campus that whether debt will matter or the consideration date will matter.
My lord.
If consideration date, then 1/6. And if debt matters, then the earlier notifications. And earlier notification did not speak of the clause 1 was
Yes,
there.
Yes, no. No,
Right.
no, it is
No
not
clause.
there.
No, clause 1 was there that
No, it
3
was
years.
not there. It was not there, your ladyship.
Then this impediment will not come.
Yes, your ladyship. I'll have my affidavit on record so that the stand
If
is
clause
clear.
1 is not there, then this impediment of 3 years will not
Yes.
come. He can be considered for compensation.
Initially,
Either
it
ways,
was
your
initially,
ladyship,
my lord,
I'll-
rejected, my lord, on that condition, my lord. I
Okay,
approached
let her
the
get the
honorable court.
Ah.
Honorable court set aside the SLC minus, my lord, and thereafter stating another, my lord, ground, my lord.
Another ground is that.
Well, subsequently, my lord.
Huh. What was the first ground?
First ground is the less than, my lord, 3 years.
3
my
years
lord.
balance.
Then next ground?
And next ground, my lord, the retrospective effect from the death.
Same.
No, my lord. Less than 3 years, my lord, prescribed in the office memorandum dated 1/6/2015. my
Acha.
lord.
On that ground it goes. That
Right.
time these judgments were not there.
My lord.
And the next ground?
And next ground stating that, my lord, that my father died prior to 1/6/2015. Therefore, 1/6/2015 is not applicable in my case, my lord, stating, my lord, subsequently. my lord.
This is also bizarre.
lord.
You say that this is not, yes, he had 3 years, less than 3 years, and then we will not. And then said again, it is not
Again, my-
retrospective.
Again, my lord.
Somehow to reject him. You file your affidavit.
Yes, your ladyship.
When can you file?
2
And bring
weeks.
the judgments after Santosh.
Yes, yes, your lady. 2
So-
weeks.
2 weeks. So this week is there, next week is there, so 28th of May or 29th of May, Friday.
Any date, your lady.
29th of May?
Yes, your lady.
Okay. Heard Mr. K.R. Padgiri, learned counsel for the petitioner, and Miss
U Sharma,
U. Sharma, learned standing counsel
government
for?
advocate, government advocate.
Oh, learned government advocate.
For respondent one,
All
not all respondent, fishery department, there is a standing. 1, 2, and 5, your ladyship.
For respondent 1, 2, and 5. Miss U. Sharma, learned counsel submits that she requires some time to bring the instructions as well as to place the relevant judgments on the point involved in the instant petition, and also has prayed some time to file her affidavit. Prayer is allowed. List this matter on 29th of May.
Elliot.
Yes, Mr. Pathak.
But this is regarding non-communication of ACR, which have led to the depriving of the particular petitioner from the third MSME benefit. But could look at
So
the last order passed.
non-communication of the ACRs.
Yes. In fact, Lordship would look at the last order passed by this court
Hmm.
on 27/4/2026.
Hmm.
Some further clarification was sought by Lord, by observing that it could
Today
not have been
CGC
accepted.
not there.
RDV. But my representation also in the affidavit, they say it's lost.
Hmm. CGC not there, Miss Devi, R. Devi. Inform her. We will take it up after some time.
I'll try, my lord. Maybe she's not around today. I'll try.
Okay, you'll try. If she's not around, we can fix it some other day, but then she was about to get the instructions.
My lord.
And what was lost?
My representation, my lord. They say
Yes.
that they have received it, but then while forwarding it, my lord, in the affidavit, they say it has somehow been lost. So it could not have been acted upon, my lord. That is the view of the court, my lord. But then she was given a chance to clarify as to what had happened.
So try.
My lord.
All of a sudden, after some time, huh?
Obliged.
Roland, 1 year, 8 months elapsed, no affidavit filed.
See, this is not done, Mr.
My lord,
Bora.
actually, my lord, extra copy is not served yet, my
I will
lord.
file, I will already start, my lord, okay, I will.
And
start
otherwise,
today itself.
my lord, the petitioner, because on the face of the documents, my
Hmm.
lord, the impugn letter at page 53, my lord.
Without the affidavit, can it be disposed of now?
No.
No? Can it be, I think, what?
Let them file it.
Yes, my lord.
Because last time you were supposed to bring instructions.
Yes, my lord, that is the instruction, because the petitioner was unauthoritatively absent, my lord, without any leave, my lord.
Hmm.
So that period, how can be regularized?
Hmm.
I will submit.
Hmm.
This. My lord. what
Subject
best
to
in
the
this case?
disposal. Can
Yes,
it be
my lord.
done? Or he will bring, you have your instructions with you?
That is the instruction, my lord.
Then you need time to file, incorporate it in the affidavit, no?
Yes, my lord.
Or it
Let's
can
file
be
it.
without
It
that
will be
also.
filed Within a week, my lord. That instruction will be.
In midst of the argument, you'll say, no, let me file an affidavit, then again, my time will go
Yes,
for a
my lord.
waste.
That will be better, my lord.
Okay, heard Mr.
Yes, sir.
J. Sharma, learned counsel for the petitioner, and Mr. D.P. Bora, learned standing counsel for Health and Family Welfare
Yes, my
Department.
lord.
Health and Family Welfare Department. Mr. Bora submits that as submitted earlier, he has the instructions with him. But he said that the same has not been incorporated in form of an affidavit, as he is yet to file. Prayer is allowed. List this matter after 1 week.
After 2 weeks, my lord,
List this matter on 3rd of June.
because otherwise he is continuing in his post now.
He has been promoted also thereafter
Yes,
also,
my
my
lord.
lord.
You were promoted.
Yes,
Yes,
my
my
lord.
lord.
Lordship will
Everything
file
is
everything.
now in order, only that must period.
Leave
Not my
period.
fault, my lord.
Only that finance money issue or what? Or any disciplinary proceeding? No,
No,
no.
no, nothing.
Fifth June, my lord.
Okay, on 5th June.
Fifth, my lord, I have some problem, my lord. Can it be on 10th, my lord?
That will be too long.
Yes, my lord.
Almost
No,
1 month.
my lord, otherwise he is continuing in the promotional post, he is getting his regular salary and everything because it is not causing any prejudice to him, my lord, at present.
That will cause prejudice during his retirement and all.
Yes, my lord, that's
Yes,
why.
that will be. that
Not
will be-
now, my lord, not at present. my
Okay,
lord.
then 10th of June.
10th of June, my lord.
Obliged.
Obliged, my lord.
Lordship, here pleadings are complete, but
Ah.
what it seems, Lordship, I think record is required.
Record is.
Yes, the one disputed.
You are supposed to file affidavit in reply, I think, that you have filed.
That they have filed, Lordship.
Mhm.
But it can be disposed to the admissions hearing itself because matter is very simple.
Without the records.
My understanding is it can be disposed without record because there is some, I'm just sticking to some law point.
Okay, let me see whether they have taken time to bring the records.
The record was directed on the, I think on 37/25, Lordship, but we are yet to receive it.
Be called for and kept ready for perusal of the court. So that is not there.
Not that there.
There is already an order.
Order, Lordship,
Lordship, then-
37/20.
Then record may be, they may be directed to produce the record and date may be fixed for admission hearing.
Lordship.
itself.
When can you bring? Next week?
Next week, it may not be possible, Lordship. May, no, Lordship. Okay, Lordship may fix it on 19th also, Lordship.
19th of May.
19th
Yes,
of May.
okay.
I'll try, Lordship, or
you try.
Lordship kindly.
Step 19.
Then 28, 20.
What?
Okay.
Lordship.
Heard Mr. FZ Majumdar. FZ Majumdar, learned counsel for the petitioner, and Miss M. Bhattacharjee, learned additional senior government advocate. Additional senior government advocate. Miss Bhattacharya, learned counsel submits that records were directed to be produced by this court by order dated 37/2025. But the same is not available today and has prayed for some time to bring the records and place it before this court.
Lordship.
List, prayer is allowed. List this matter on 19th of May, 2026.
20, Lordship. He's
28th,
telling,
yes,
Lordship.
20. 28th of May, 2026.
Be careful, Lord.
There's 16, no counsel. Who's there? F.A. Laskar. After some time or what? So irrigation person, you inform, you all are same, both brothers. So you inform irrigation to be here. We'll take it up after some time. Let's see when the council might turn up. Allah peace. Yes.
For the last occasion, the government is supposed to file that affidavit.
We have received the pair-wise comments from Directorate of Information, but the pair-wise comments needs to come from the government. Because the government is the main authority who will regularize the period. So otherwise, this affidavit is necessary, of course, from the Directorate also, as well as the government. We have received it from the Directorate, but need some time to get further instructions from the government regarding that.
Directorate information and government information will be two separate things.
Yes, the government is represented by the department, and Directorate says in their pair-wise comments that the government will regularize. So the say of the government is very much necessary. So I have to get instructions on that particular aspect as to how to treat that particular period. Because the government, they say that only the government can regularize that period. And of
This
course,
non-regulation matter.
no, regulation of pay.
Oh, regulation of pay.
So
So
They have
let,
otherwise stated that they have regularized. AG is also there. AG is they will also. They, because the directorate says
Mhm.
that the AG will have to give the confirmation regarding this regularization. So everything, we will file the affidavit and everything.
then there has to be many affidavits then,
Yes.
one by directorate, one by government and one by
Department.
AG.
AG also.
AG who is appearing, Miss M. Bhattacharya?
No.
No,
AG, they were standing counsel, Your Lordship.
Accountant General. I think there was one who used to appear.
There are many set of counsels, Your
Acha,
Lordship. That's it.
Okay, you inform them as well to file the affidavit
Yes.
and we'll fix it up after 2 weeks.
After 2 weeks.
2 weeks will do.
Lordship, a date will be fixed.
Date I'll give.
Your Lordship, make it, Lordship, make it 3 weeks because we have to get the instruction. Then again, we have to file an affidavit and get it vetted and signed. As for it will take some time. June 1st week, Your Lordship.
Otherwise, when was the matter filed? 2025?
25.
June 25.
June.
Yeah, almost a year now.
Almost a year.
So
Otherwise,
file it.
yes.
Heard Mr. Chetri, A. Chetri, learned counsel for the petitioner, and Mr.
D. Bora.
D. Bora.
Government.
Bora, you are a government advocate.
Yes.
Mr. D. Bora, learned government advocate
1,
And-
3 and 4.
for respondent number 1, 3, and 4. And you are there? And Miss S.K. Megh. Camp Raya, okay. For respondent number 7 and 8. Who is 7 and 8? You also have not filed any affidavit?
They also need to file an affidavit.
Karbi Anglong, Autonomous Council. Okay, so you file it. You are required to file or not?
They are required to.
Okay. You also file. And then who appears for Accountant General, you tell that set of advocates,
Yeah.
whoever you have. And Mr. Whose name should I put on? Yes, Mr. Roy?
Mr. B. Chakraborty.
B. Chakraborty.
B. Chakraborty is a standing counsel.
Biplab Chakraborty.
Biplab Chakraborty.
Mr. B. Chakraborty, learned standing counsel for Accountant General.
It will AG.
Who's for 2? Finance Department?
17.
Finance Department, Finance,
Finance, Your Lordship,
Mr.
P. Nayak, Your Lordship.
P. Nayak.
Yes.
Mr. P. Nayak for respondent number 2. The learned counsels for the respondents have submitted that, the learned counsel, Mr. D. Bora, submits that, that he has the instructions from the Director of
Directorate of Information and Public Relations.
Director of Information and Public Relations, but he is yet to incorporate the same in the form of an affidavit. Full stop. He also submits that instructions are awaited from the government side,
From the Department of Information and Public Relations.
from the Department of Information and Public Relations, for which he will again file a separate affidavit. The learned counsels for other respondents have also, you are there? Okay. I have recorded his presence. I have also prayed that they may be also given some time to file their affidavits, respective affidavits. Prayer is allowed. List this matter on 5th of June. Will it do, Mr. Bora?
12th of June, Your Lordship.
12th of June.
12th of June.
Okay, list this matter on Chetri, it's okay. List this matter on 12th of June, by which date it is directed that all the respondents should file their respective affidavits. List accordingly.
Oblige, Your Lordship.
Ouch.
behalf of Rita Devi. Lordship,
You are a CGC.
CGC. I am not the CGC. I am appearing on behalf of her because of her brother's medical issues. She is at Kolkata. Lordship.
R Devi.
R Devi, Lordship. So
R stands for
Rita Devi,
Rita Devi.
Lordship.
Okay.
So Lordship, matter may kindly be taken up after 2 or 3 weeks because some.
Where is Mr. Pathak? I told Pathak to send information to you and then you had come, not Mr. Pathak. Okay, when do you want? When can she appear?
After 3 weeks because kidney transplantation is going on her.
Her mother's
brother.
brother.
Yeah.
Okay, you right. Heard Mr. B. Pathak. Learned counsel for the petitioner. And Mr. Bora,
A.R. Tahbildar on behalf of R. Devi.
I'm on behalf of Miss R. Devi, learned CGC. The learned counsel, Mr.
A.R. Tahbildar.
A.R. Tahbildar submits that Miss R. Devi, learned CGSE, is occupied with her brother's surgery in Kolkata, and as such, time is prayed for. The same is allowed. তার report এটা লিখাছোন, তার report এটা, that Miss R. Devi, learned CGSE, was supposed to bring the necessary instructions as per order dated 27/4/2026. তাৰপিছত কৈ দিবা যে he is apprised that she is occupied with her so and so. Prayer is allowed. List this matter on 10th of June. Okay, 10th of June 2026. In place of R. Devi, someone else can also appear.
But she has been handling the matter and
She is
the
handling.
communication regarding the records also she.
If by 10th she does not appear, then give it to someone else.
I'll communicate.
You communicate.
All right.
Near future, I may be allowed 2 weeks time to file affidavit matter.
Acha, this was, why was it deferred?
You know?
Why was it deferred today?
I was.
Oh, you were not
Yes.
there. Acha. You are for the irrigation department.
As per 1, 2 and 5.
You will file your affidavit. File it soon. I'll give you 1 week's time.
My lord, instruction is not yet complete, my lord, that's why.
Instructions you have not got.
Not completed, my lord.
Some you have got.
Some I have got, only parallel comments I have got, my lord, not the supporting documents.
Okay, heard, Mr.
F.L. Oscar.
F.L. Oscar, learned counsel for the petitioner. And Miss
D.S. New, for
D.S.
12
Neo,
5.
learned standing counsel for irrigation department. And Mr. Rahul Dhar for respondent number 6. Learned counsel will do, learned counsel for respondent number 6, and Mr. Bora for respondent number 3. D. Bora, it is Miss Neog, learned counsel for the irrigation department, prays for some time to file the necessary affidavit and also for the instructions. As she submits that she has got part of the instructions and not full, prayer is allowed. You'll also file, no.
Only accountant general also like going to file in this case, my lord.
So they are not there, you file it. Prayer is allowed. List this matter on 1st of June.
Deeply obliged.
1st of June will be late, will be very late. No, no, it's okay.
But the petitioner.
So affidavit reply you have filed?
Yes.
So pleadings are complete?
Yes.
Okay.
Under the petitioner,
Hmm.
senior most teacher of his school, my lord.
Hmm.
I take the lordship to the annexer 1, page 21, type copy.
Page?
21.
Yes.
Lordship will find the extract.
Petitioner is Tankeshwar Nath?
Tankeshwar Nath.
Okay.
And he is the senior most teacher of the school, my lord.
So date of joining was 92?
Yes.
Then what happened?
Then, my lord, he was earlier principal of the school has retired, my lord, in the year 2023, and thereafter, my lord, annexer 2 you will find it was given one charge to another teacher.
No, I couldn't get you. What
Page 25.
he was working since 92?
92.
Then page?
Page 25.
25, what happened?
It was his junior Jiten Chandra Burman was given the charge of the principal of the school, my lord, in the year 2023.
So your contention is to get the post of principal?
Yes, sir.
Principal in charge, your lord.
Principal in charge. What
So this Jiten Chandra Burman was allowed to hold the in charge of principal?
Yes. Thereafter, my lord, his approach this honorable court in page 26, annexure 3.
Yes.
And he was rejected mainly on the ground that he was not having the NOC while procuring his master degree. Not NOC means, my lord,
His claim for the in charge principal was rejected
rejected.
by this order, 1812, 23.
23rd, page 25, he was
Ah.
not given, meaning thereby his claim was rejected.
On what ground?
Mainly on the ground that he was not having the NOC from the department before procuring the master degree.
Acha, you need one NOC before procuring master degree.
Master degree,
Master degree he procured when he was in service.
yes, in ODL mode.
Hmm.
Thereafter, he approached this honorable court and
NOC from the department.
yes,
Then
Annexure 3, page 26.
Ah.
Lord will find the 11th page I'm taking, page 31.
Acha, that ground for rejection was by the department.
Yes.
Now then,
That
you
was
had-
put to challenge in this writ petition.
Hmm.
Then this honorable court at page 31, my lord, and page para 10,
Hmm.
issued mandamus. Accordingly, the matter stands remanded back to the Director, Secondary Education Department, who shall now pass appropriate orders, allowing the petitioner to hold the charge of the post of principal, Shortebari Higher Secondary School, Shortebari, after due verification of the particulars of all the candidates in play.
So what did the court say? NOC is not required.
NOC, my lord, there's a condition is there. You should find it is there in the judgment is analyzed.
Where?
Page 30, I may read, madam.
Hmm.
Paragraph 6.
Okay.
The said issue no longer res integra, and in this court, by the order it is passing had held that if a degree had been obtained without prior permission of the appointing authority, the same would not be a misconduct.
Would be.
Yes.
The same would be a misconduct.
Same held that if a degree had been obtained without prior permission of the appointing authority, the same would be a misconduct under Rule 13 of the Rules 1965. And being a misconduct, the relevant proceedings of law applicable against the candidate would be proceeding against such candidate under such rules, but the same by itself cannot invalidate the otherwise the valid degree obtained from the respective universities, and further that the degree obtained from a university is governed by Section 22 of the University Grants Commission 1965.
So against him, proceedings can be initiated, but not this way.
But
he cannot be denied his claim.
Yes.
Hmm,
And
then?
therefore directed. After that, my lord, Annexure 4, you will find.
This is correct, Ms. Mushahari.
Lordship. It has been settled, your lordship, that it will not invalidate the degree. However,
You can
it-
proceed against him,
yes,
but
yes,
then
yes.
not invalidate.
Lordship.
And on that ground, it cannot be refused.
Yes,
Yeah.
Then,
Thereafter, my lord, they have again issued the another rejection order, Annexure 4, page 33 onwards, my lord. And thereby, my lord, they have directed the inspector of schools to initiate the departmental proceeding against the petitioner.
and he was not allowed to,
And was not allowed.
in spite of the court's order.
Yes.
Because court's order was only to reconsider.
Yes.
Hmm.
And thereafter, my lord, again, he have approved this honorable court, Annexure 5, challenging the that order, that impugn order. Initially, the order stayed, and thereafter, my lord, it is interfered with all the cases. He has filed 3 cases. One challenging show cause notice, one challenging the punishment, 2 punishments imposed upon him. All these 3 cases filed, and 3 cases have been allowed, quashing all the proceedings and the punishment.
So this is a common judgment.
Yes, it's a common judgment, and this honorable court has set, my lord, certain.
Acha, no, he came against his this order dated this one, Annexure 4.
Annexure,
Right.
Annexure
He challenged this order,
This order.
and he challenged the show cause notice.
Yes,
And third petition was for what?
punishment. He
Or
was-
disciplinary proceeding was over and punishment was
Punishment imposed.
inflicted.
Yes,
Acha.
and
okay.
all the 3 cases.
What punishment was inflicted?
Warning and some.
Censure.
Yes.
Okay, then.
That is, all these things put to challenge in 3 cases, and all the cases have been heard together. And my lord, it was allowed, and all the punishment and the proceedings were set aside.
So page
This-
43.
Yes.
The petition squarely covers the case. During the issue is usually possible higher standards to distance what according to the determination of 4205 and another connected to petition order later email.
You will find at page 42, Roman 7 para.
Roman 7, okay.
held that distance mode, if someone takes a degree in the distance
Hmm.
in ODL mode, my lord,
Huh.
from KK Hendik, Ideal, Gauhati University, Dibrugarh University, and Assam University,
Hmm.
and that will not
In
amount to
terms of
violation.
prescription made under OM.
Yes.
So and so, therefore, Rule 13 cannot be made applicable to districtors taking due from observation made in Mosumi Chaharia.
Yes.
Accordingly, if any proceeding has already been initiated again or during the pendency of the same shall fail. So even starting proceeding, initiating proceeding is wrong.
Yes.
What is Mosumi Chaharia case?
Mosumi Shoria, my lord, there the Honorable Court held that for the departmental authority cannot declare the degree invalid.
From distance mode, in
Yes,
distance
i- i-
universities.
Any degree that the authority which has issued the degree is the only competent authority under the UGC Act, my lord, to declare the degree as invalid, not by the departmental authority. And my lord, in this case, my lord, when an incumbent takes a degree in ODL mode, that does not, my lord, amounts to violation of Rule 13 of this 1965 rules.
Mm.
Therefore, my lord, all these proceedings and show cause punishment, everything has gone.
Mm.
Thereafter, again, my lord, they have filed, issued another impugn order. This is put to challenge here. And
They are bent upon not giving you.
yes.
Then-
Now they have come with a new ground, my lord,
Hmm.
that I have on the day of my issuing this order, I have completed more than 57 years of age, and therefore I am not entitled. As per rule, as to 2018 rule, the rule is that, my lord, one must have 17 years of teaching experience, one must have B.Ed degree, and one must have master degree to hold the charge of the principal. And apart from that, one must be 57 years of age.
Must not be
while-
more than.
Must
More
not
than.
more than
Mm.
57 years of age on the day of taking over the charge. It is not for, it is for the direct recruitment,
Mm.
but this is the rule, madam.
Acha.
So, and they have taken this ground now, and as my age is more than 57 years, I am not entitled to take the charge of the principal.
Fair enough.
That's
According to rules.
that's a, they have denied, madam.
Yes.
So my question in this, madam,
Again, you file writ.
again I have filed it.
Hmm.
Again,
Half of the time
again-
gone in your court's business.
Yes, yes.
Yes,
This is,
then?
this is the case, my lord.
Hmm.
Now, my lord, I have filed-
Challenge that order.
No, I have filed one additional affidavit.
Hmm.
Additional affidavit, my lord, your lordship will find. This is I have given one example, two examples of an.
Acha, this is what you have challenged now.
Yes,
your
this is the
Acha.
challenge here.
So this last order,
This is last
57
one.
years.
Yes, 57.
Hmm.
And I have, my lord, put to. I filed one additional affidavit. Your lordship will find annexed 8A, page 54.
And what is this order that you have annexed
This
after
is,
your order?
They have rejected my SCR, and ultimately SCR has been cleared up. They have submitted ultimately for the promotion to the post of headmaster. I have therefore that annexer, that request has become infructuous. They have rectified it. My
No,
lord,
this order you mean 10/4/2025.
yes, that's it. Last, I have given the High Court annexer 7. Yes.
Huh.
That was, my lord, another requisition I filed, whereby, my lord, they have rejected my SCR,
Hmm.
and I have put to challenge. And during the pendency of that case, my SCR has been rectified and submitted by them
Acha.
for the promotion to the post of headmaster. It's a separate issue, my lord.
Oh. So this petition was closed.
Yes, yes.
No.
Now, my lord,
Till the next date are not directed. This is an interim order.
yes, interim order it is closed, vacated, everything.
Later.
Yes.
Huh.
My lord, annexer 8A, your lordship will find additional affidavit I have annexed. In order to bring the example, my lord, this is the school, my lord, public higher secondary school, Hailakan.
Acha, what is the page?
Page number 54.
54, yes.
Your lordship will find, I have given one, your lordship will find HR Mojumdar
Hmm.
and Nurul Islam Loskar,
Hmm.
2 persons.
Yes.
Here, my lord, date of retirement, your lordship will find 31/12/2023.
Where is
The
that
middle,
date? Yes.
column number 8.
Yes, 31/12/23.
23, and you will find in serial number 28/2/2024.
Hmm.
Yes, next page I take your lordship, page 55.
Why are their date of retirement important in this case?
Yes, my lord, because they have rejected my case on the ground of 3 years.
Acha.
That's why.
Hmm.
You will find annexer 8B.
Hmm.
The order was issued through Mr. Habibur Rahman Majumdar.
Hmm.
He was allowed to hold the charge on 30th December 2022.
Hmm.
And his date of retirement was, my lord, your lordship will find 31/12/2023.
But if something wrong is done in respect of other person, how can that
That is
give
not-
you?
That the practice is that, my lord, they are even allowing the teachers only with, the rule is applicable only with me. And that rule is not for, my lord, promotion. It's a direct recruitment. Only for direct recruitment, the candidates who is having 57 years more cannot apply.
Hmm.
Post of principal.
Okay, I'll have to see the rule.
Yes.
Huh. But then this is in respect of similarly situated people.
Similarly, they have allowed.
They have more than 57 years of service, but then still.
Yes, in this regard, this honorable court in these proceedings had many occasions asked them to give the query and give the as to why it is done, and as to why it is not done in case of the petitioner, but they have remained silent in the affidavit also.
Anyway, that plea you cannot take if something wrong is done. In your case also, they will do the wrong. It's not a case.
They are doing, my lord, it is not a direct recruitment.
Ah, that
Rule
can be
is not a direct recruitment. They are not doing the direct recruitment in charge basis. In charge is always given to the senior teacher of the school, my lord. And, my lord,
And there is provision for direct recruitment to in-charge principal.
no, no. Direct recruitment is throughout the district is taken, but it is not taking place. As because it is not taking place, the in-charge, the school has to run. Therefore, this in-charge has to be given. The charge is given to the senior most, practice is that the senior most teacher is always given the charge. Qualified eligible teachers. But the petitioner has been deprived.
But if he doesn't fulfill other criteria,
The cause of action in this case is the cause of action which is arose, my lord, in this case in the year 2023. On the day itself, I was qualified. It is only for their administrative negligence, and they have deprived me. It is their arbitrary action.
now that his years have gone, now that his age has.
They cannot bring it back. They have done wrongs. They cannot say that I was not eligible on that day when they have issued the first impugn order. I was eligible, and this is established by this honorable court. I was eligible, and it was directed to give me the charge. But only they are doing the wrongs, my lord, one after another.
So that if I allow your case, then he has to be given with effect from the earlier date.
Not effect from, it will be from the current date because it cannot be.
Current date he is not eligible.
As because the cause of action, my lord, your lordship will find it has come in the year 2023 when I was eligible and qualified.
That I have understood.
Yes.
That you have said.
Yes, because
Now what do they say? Yes, Ms. Mushare?
now they have filed one affidavit, my lord. In the affidavit, they have taken a different stand. They have, my lord, yes, because they have not found any other grounds. They have developed a new ground. They have issued one show cause notice to me. Another show cause notice to me. They have brought a new ground, my lord, that I was, while swearing this affidavit before this honorable court, I have not taken leave. They have taken this one additional ground, and therefore it has amounted to misconduct.
So you were working when you had signed the affidavit?
Yes, they have stated like this one.
Then?
And in this regard, I have submitted the reply, and I have clearly stated that I have taken permission, and in the evening after school hours, I have come to Gauhati. It's from Borpeta. I have come to Gauhati and I have notarized. That is, they have done nothing thereafter. They have, as because they found that they have, I have annexed the attendance sheet also. It was given CL in the attendance sheet one day. And one day after evening, after school hours, evening, I have come. Sunday was, so I have, with stationary permission, I have come. I have given all these things there to them. They have become silent. After they have done nothing. Now the question, my lord.
But you had taken CL.
Yes.
But then you say that after office hours you have come.
2 days. 2 days.
2 days.
One day I have taken CL, and one day after school hours. Because it's from Borpeta, my lord. I can come easily.
You want 2 days?
Yes, for two cases, earlier cases, they have taken this plea. That is it. And my lord, I want to place one judgment, my lord.
No, finish the pleadings first. Then this is the case.
This is the case. This is the case.
There are more affidavits here.
I have given.
Oh, you have filed your reply.
Yes, I have filed the reply. In the reply, I have given.
That you had taken permission.
And in the reply, I have given my lord. Admittedly, the private respondent is junior to me. There is no dispute with.
Oh, there is a private respondent also.
Yes, he has filed also affidavit.
Who is appearing for? You're there.
Private respondent.
Now you are in charge of the school.
Order number 1821 since 2025. I'm the eligible teacher, though I'm junior, but I am a BA exception. I have been receiving post-graduate scale of pay from 2009.
He also is eligible according to the judgments.
That is not the issue.
Because it is said that proceedings can be initiated, but he cannot be deprived.
Isn't another proceeding?
Again, a show cause, not taking leave.
Yes.
For insertive also, my lord, the
It feels like they are bent upon one or the other. Yes. This is the judgment.
Yes, it's the paragraph 19, my lord.
Paragraph 19.
Yes, the concept of a fresh cause of action
Hmm.
and a continuous cause of action was considered in the decision reported in such and such. What is a continuous cause of action? Speaking accurately, there is no such thing. But what is called a continuous action action is a cause of action which arises from the repetition of acts or omission of the same kind as that for which the action was brought.
So this is not of the same kind.
My lord, depriving me from
Wait, let
holding
me
the
read
chart.
the sentence again. This is in the words of Lord Linley.
Yes.
What is a continuous cause of action?
Yes.
Speaking accurately, there is no such thing. But what is called a continuous cause of action is a cause of action which arises from the repetition of acts and omissions of the same kind as that for which the action was brought. But then your all cause of actions are different.
Different means, my lord, depriving is depriving from holding the charge, the same cause of action, my lord. That they are doing this year.
But reasons are different.
Reasons may be different, my lord, but by my deprivation is the same, my lord. In the same decision, Lord such and such in a concurrent view said, if a cause of action arises and the acts complained are of continuously repeated, the cause of action continues and goes on, did I in them, it seems to me that there was a connection in the present case between the series of acts before and after the action was brought. They were repeated in succession and became a continuing cause of action. They are an assertion of the same claim. Claim is same. Namely, a claim to continue to pour wages into stream and a continuance of the same alleged right. Right is same alleged right, my lord. In my opinion, there was here a continuing cause of action within the meaning of the rule.
See, here facts are, I think, pouring of sewage into a drain,
Yes.
into a stream.
Yes.
So a claim to continue to pour sewage into the stream and a continuance of the same alleged right.
Yes. Right is, my lord, here to get the right to get the charge of the principal. Paragraph 21, my lord. At home in this decision reported in such and such, it was observed that it is the very essence of a continuing wrong, that it is an act which creates a continuing source of injury and renders the doer of the act responsible and liable for continuance of the said injury.
How this case is applicable to you?
Because, my lord, the acts they have done has given me the injury continuously, and my same
You have
right,
taken it in the other way out.
my right to claim, my lord, for that is the same thing. In each and every proceedings, my direct or indirectly claim is to get the charge of the post of principal. That they are denying this way or that way, my lord. Therefore, it is a continuous acts, my lord. It can, and all the wrongdoings.
But this case is different. This continuous acts in case of
this
petitioner.
I have given, my lord.
Now you are saying continuous acts of the respondents.
Yes.
This case is actually other way out.
Yes, respondents. I'm
Right. This case is in respect of continuous act of the petitioner.
Petitioner, but
You could have got a better case than this.
the cause of action, in order to give the definition, to understand the cause of action. Cause of actions, my lord, it is the same cause of action. That I want to mean, my lord. They are doing this way or that way, but the cause of action is to get the charge of the principal. This is the denial of the charge of the principal is the main source, only the cause of action.
Okay, any other case?
Continuously.
Any other case?
And my lord, I'm giving
Let's see what days I have to say. Let's see.
just one case, my lord. That
This is Delhi High Court.
yes. This is, my lord, one mere issuance of the shockers, my lord, cannot be a ground to deny
Paragraph
me.
12 and 14.
Yes, yes.
But this again will not be applicable. In your case, okay, show cause notice was issued. No departmental proceeding as such till today.
Yes.
But you have a service to render. Here the person was
Just
retired.
Right.
That is why it is said that during retirement, there was no question of in starting a departmental proceeding.
Yes.
So that was said that simply issuing show cause notice would not be enough. But in your case, it is different. They might again start a departmental proceeding.
They have not done anything, my lord.
They have not done, but you have many more years to go.
No,
Three
he's back
years.
the next year, my lord.
Lordship, DP has been initiated, SOCOS has been issued, DP has been initiated. So
So-
departmental
And
proceeding
that
has
cannot be ground,
started.
my submission, is that cannot be a ground to my deny the charge. Because once, 3 times this honorable court has directed, my lord.
Hmm.
And continuously, my lord, you also will find in page 22,
Hmm.
the gradation list. The seniority list they have prepared on 16 to 2023.
22.
Yes, yes.
Yes. That you have shown.
Yes.
Huh.
On the vacancy arose on that day.
22. 22
Yes.
you have not shown. What happened? 22?
22 is the gradation list. You also will find. See, seniority list of the schoolmen.
So Gajendra Burman is the first.
My name is Tonkeshwar Nath. Page number 23 you also will find. Seniority determined not on the basis of serial of the minor, it is determined on the basis of the date of getting the graduate scale of pay.
Respondent number 4 is senior to you.
No, my lord. My you also will page 23, you also will find my date of getting graduate scale is 30/12/1993.
Oh, yes. Then this
And-
is not a gradation list. What?
Yes, and he has got, my lord, on 2009, 5/9/2009.
So how did he surpass you?
Because he is in the high school, therefore high school part is taken first and therefore higher secondary.
That is why.
He is in the higher secondary, therefore he is the come above. But in high school section, I am the first, and overall I am the first.
So he is in the higher secondary.
Higher secondary, but a combined, it has to be taken in the combined manner.
Okay,
Combined
we will hear him what he has to say.
It has to be determined on the basis of the date of getting the graduate scale of pay, not on the basis of the serial number of the seniority list. He
Date
has
of
got in the
getting
year
of
2009, he is much.
so date of receiving graduate scale of pay
Yes,
in respect of you, it is what?
it is, my lord, 30/12/1993. And he is 5/9/2009.
Okay. That is your case?
Yes, yes.
Let's see.
Therefore, my submission is that, my lord, 57 years, which they are hampering, my lord. This is, my lord, for the direct recruitment.
Where is that? Show me the rule.
Rule 12 of the 2018 rule, my lord, page number.
Yes, नहीं है. Service.
Education manual.
It is for the direct.
Service manual kon dille পাম চাগে.
It নহব.
Manual, education manual.
Education manual খন হ'ব নি?
এইটো দিয়ক, তলৰটো দিয়ক।
Green.
Greenটো দিয়ক।
This one, education manual, yes, it খন দিয়ক. So what rule you said?
Page 32, I think, my lord. It is the Assam Secondary Education Provincial Schools,
Hmm.
Service Rule 2018. Rule 12.
12.
Post of principal is product.
So what does it say? The post of principal in provincial law was filled up by direct recruitment from the candidates amongst the cadre of postgraduate teachers of senior secondary and higher secondary school. Yes, this is a direct recruited post, but this is not, you cannot say that direct recruit from the teachers, from the head teachers.
Not head teachers, from
From
the graduate
the-
teachers.
Uh-huh.
Graduate
From the
teachers,
candidates.
From the graduate teachers and the postgraduate teachers,
Mhm.
they can apply for direct recruitment. Having the 15 years of service in case of postgraduate teachers and 17 years of service in case of graduate teachers. They can apply.
Huh.
And for applying to the direct recruitment, age should be maximum 57 years. But not for taking the charge. It is the district level recruitment.
So this principle will not apply to in charge
Yes,
principal.
yes, it cannot be applied. Because in
Where is
schools,
the provision for in charge?
there is no such provision.
Memorandum? Something?
No such provision. Memorandum, my lord, I can, my lord, your lordship, if your lordship takes it too, I will give one memorandum I have got that with regard to handing over the charge.
In charge?
Yes, it is in the year 2015 that I have collected, that I can give at 2.
You should have brought it now.
That I-
Anyway, let me hear Ms.
Yes.
Mashahari. Yes.
Lordship, with regard to whether the rules will be applicable to in charge principal or the headmaster, your lordship, in Jagannath Pegu, it has been clearly stated that whether it, even in temporary appointments or in charge appointments, your lordship, the rules will be applicable. They have to fulfill the eligibility criteria, your lordship. Only those who fulfill it, only they can be made the in charge. So that is.
So this
that
will be
has-
applicable.
Lordship. In Jagannath Pegu, it has been clearly stated and we have followed it, your lordship, till date. And lordship, regarding his, so 57 years of age, if we go by that ground, your lordship, then he has to be less than 57. He cannot be more than 57 years of age. As of now, your lordship, we have filed our affidavit, page 62, your lordship, paragraph 5 will be relevant. Dear 5, your lordship, we have stated that we have conducted a hearing. It was conducted on 22nd, 9, 2025. 17/10/2025, your lordship. And we have stated below in Roman 1, your lordship, the certain facts have come. There we have noticed that he was, without taking leave, your lordship, he was unauthorizedly absent, your lordship, without taking the permission. And that is why we have issued so-cause against him, your lordship.
But this is in respect of leave on 4/4.
Yes, your lordship.
April
4/4/2025.
and 24/6.
24/6/2025, your lordship. On 4/4/2025, your lordship, he was here before the notary, your lordship. And in the attendance register, it has been shown that he was present, your lordship. So that is why we have initiated, we have issued.
But he said that after office hours, he came to Gauhati and then he signed.
Lordship, but here what we have stated is that he was not there. Otherwise, in the attendance sheet, he was. That is why we have issued so-cause, your lordship. So DP will be initiated. So in that inquiry, he'll be given a chance, your lordship. to place.
And any continuance of inquiry will debar him from taking in charge.
So see, why we do not insist on making him the in charge, because DP has been initiated against him and there might be some tampering, because he will be the in charge principal. The registers will be in the school, your lordship. It will be under him, your lordship. So so that the registers are not being tampered or any evidence are not being tampered, that is why we do not want to appoint him as the in charge principal till the proceedings
Four,
are.
426(4) were in your knowledge beforehand. Now this is a cause of.
That was given through the WhatsApp group. Permission has to be taken. There has to be proper permission.
But this fact were known to you earlier. Now you issue show cause
this was
notice.
not there. This was 4/4/2025. He was not there, your lordship.
No, this is a show cause notice. When did you issue this?
It was issued on your lordship.
During this pendency, madam.
During pendency of this writ.
Yes.
5/5/1/2026.
So January.
In order to
5/1
answer.
Oh. 5/1/26.
Yes.
5/1/26, page 68, your lordship.
Page 68. This is the show cause.
Lordship. That while you were in service and serving as assistant teacher of so-and-so school, you have signed affidavits before the notary at Kamrup district on so-and-so and so-and-so.
This was when April 2025 was during pendency of your earlier writ petitions.
Yes, your lordship.
Which was disposed of by,
11.
where 3 writ petitions were disposed of.
Yes, your lordship.
That show cause and this show cause is different. Different, right?
Different. That is different.
And that time you could have,
They have not done this.
that time you could have issued this show cause.
It was after the hearing, your lordship. That only that time it had come to our knowledge, your lordship. A hearing was conducted, your lordship, on 22/9/2025 and 17/10/2025, your lordship.
No, that is after this show cause. Oh, that is after this dates. Right.
Show cause was issued after these dates, your lordship. After
5/1, January 26.
Yes, your lordship.
For his misconduct on April 25.
Lordship.
Now, earlier show cause notice was for what purpose?
For not why as to why I have not taken NOC from
NOC
Oh,
from the,
NOC from the department.
lordship. That was a different issue, your lordship.
Where is that show cause? Have you annexed?
that, my lord.
Or we will get it in the order.
Yes, okay.
I just want the date of that show cause.
The lordship will find in the order itself it is given.
Where is the judgment?
Judgment start from, my lord, page 36. Page 43, my lord. So, of course, earlier one, 19/4/2024. Page 43.
19/4/2024.
Yes.
Okay, I'll come back in 2 minutes, 5 minutes time. That after a hearing done,
Not sure.
this show cause was issued.
Yes, your lordship.
But before show cause, any hearing is required to be done, not required.
Not required, your lordship. But that sometimes such preliminary hearings are made.
This is what?
The guideline for
Oh, acha.
giving.
But then she said that there is a judgment where it is said in charge temporary arrangement.
Judgment
These.
not against the judgment, my lord. Judgment
Huh.
says as per rule. The rule says the direct recruitment, and to overcome this, they have issued this office memorandum. It was in my different file that collected it.
Oh, dosa khula sin.
2003, 2012 project. No, it was in between the. How will this, when we try to do this? This will not be applicable. No, applicable. Theoretical.
Okay, according to this memorandum, this, whatever you
was
say,
the
notification.
Practice is that.
Also, this circular was issued in pursuant of the earlier, the repealed act and rules, your lordship. Now the new act has come, now there is a judgment of this honorable court, your lordship, so that will be applicable, your lordship. Because eligibility criteria has to be followed.
This is in respect of 2003 rules.
Lordship.
Now that
Because
18 has come.
difference between the 2003 rules and the 2018 rules is that, my lord, earlier the school-wise principal in the direct recruitment is there. Earlier it was school-wise direct recruitment, now it is district-wise direct recruitment.
That will not make
This
a
is the
difference. District,
Nothing else.
Lordship, eligibility criteria will be different. School
Not,
and
no
district-wise
eligibility criteria
doesn't matter,
different, my
your
lord.
lordship.
Your lordship will find that 17 years, 15 years, this is there, MA, BEd, MCom is there, my lord. There's nothing else, my lord. Only the difference has come, my lord. Earlier it was school-wise direct recruitment.
The head teacher of the school will be appointed as in charge.
Not head teacher, it's just
Senior most.
senior most PGT and TGT teachers. Amongst both the categories, so who will be the senior most will be given the charge of the principal. This is the practice. And the post of principal should be filled up on direct recruitment basis. Earlier it was school-wise direct recruitment, and now it is district-wise direct.
District-wise direct recruitment means
But district level committee will be there.
a person from another school can come and join.
Yes, yes. Earlier also it was there.
But he loses his seniority.
The question of seniority in respect of direct recruitment does not arise. Only the eligibility criteria will be applicable. Whether he is having 17 years of teaching experience, a master degree, and BEd degree. That is the sole criteria. And it was only for direct recruitment. From any other school, he can come, no problem. But in case of charge, yes, senior most teachers of the school having this qualifications will be given the charge. That is the basic principle, and they are following this, my lord, and therefore I have shown your lordship that they have given charge to other teachers who are going to retire within 1 year. That annexer 8A and 8B I have given. This is the reflection on the basis of this guideline.
Now our ground for not allowing him is that because DP has been initiated, there is a department proceeding against him, your lordship, and that is why we do not want to allow him to be the in-charge principal, your lordship, because.
Fact remains the DP has been initiated. Now, if you are appointed as in charge, you will have access to all the records and all what they are fearing.
Records they have collected, they have stated in the focus notice itself. That is, they have collected. And what the record they have collected, I have given the reply to that. Let me read my reply, my lord.
Okay, let her finish. Then what else you have to
No,
say?
sir, this is the ground why we have not allowed him to be the in-charge principal, even though he has the seniority. Otherwise, lordship, rule 12 is against him, your lordship, because he is more than 57 years of age. And now since DP has been initiated against him, your lordship, we cannot allow him to be the.
What do you say on others being considered even after their 57 years of
So on
age?
that, we do not have the instructions. However, your lordship, the way, because the rule has to be followed, your lordship. Maybe only because in those cases, the negative writ will not be followed here, your lordship. Because the rule has to be, we have to follow it. If there it was done, then it was a wrong. Here we have to follow it, your lordship, because he has to fulfill the criteria, your lordship. As the Jagannath Pegu's case, your lordship.
When are you going to retire?
Next year, my lord.
Why? What is the retirement? 62?
60, your lordship.
60.
60.
So now he is almost 58, 59.
Lordship.
But then you see every time you had raised some issue against him.
Because initially because of the NOC, and after that the court has settled the issue, and by the time his orders were set aside, your lordship, he was already more than 57 years of age, your lordship, and that is why again we said that because he was more than that, we cannot allow him. And after hearing was.
But then he became 57 plus because of these litigations.
Lordship.
Where have you written that? I forgot. Where have you written? That, yes, you had come after finishing your office work.
Yes, I have given in the reply, my lord. I have annexed the reply in the next 9 page 83.
Page?
83.
So what reply you have?
Reply, yes, as regards the charge 1.
So this is reply to your show cause?
Yes, yes, yes. Reply to show cause is annexed with the affidavit in the reply. I have given. That as regards the signing of the affidavit before the notary public at Kamrup Metro District on such and such day, it is humbly stated that the undersigned applicant has applied for only station leave permission after school hours. Accordingly, he has arrived at Gauhati to sign his affidavit for filing a writ petition. After signing his affidavit in the evening, he left for Borbeta on the same day itself and reached at home at night. As the undersigned has signed the affidavit in the evening hours on 4/4/2025, the writ petition of the undersigned could not be filed on that day. The writ petition of the writ petition is therefore filed on 5/4/2025. The by filing number such and such, it is recorded, and subsequently the same has been registered on such registered by number such and such. As the undersigned has not taken CL, he therefore attended the school till the school hours, and thereafter he started for Guwahati with station leave permission from the concerned in charge head of the institution. As the concerned authority has allowed the
But you
undersigned,
have not taken CL, it is said, but in their affidavit, what did they say? They have taken leave.
Actually, we have stated it as per record, page 63, Your Lordship. Record of the attendance register as well as Diksha Setu app. This is the Lordship, this is an app, Your Lordship, where they have to.
Where have you
Page
stated that he
63.
attended school and it, what?
Page 63, Your Lordship.
Hmm.
As per record of the attendance register as well as Siksha Setu app on 4/4/2025, petitioner was present in the school.
Was present in the school.
He was present in
that I am admitting also.
He is admitting. So what is the problem with that? He was present, he said. Evening hours he came. Signed. Petition was filed on the next day, 5. So what have you said about taking leave? No, nothing.
Clause B, my lord, page 84, I have given the answer.
Wait. Let her show her pleadings.
Because we have stated that as per the office memorandum, before leaving the headquarter, one has to take the permission, Your Lordship. And
That station leave he had taken, he said.
Lordship, here station leave, we said that has not been taken, Your Lordship. That is what we are saying.
Achha. That is not found in the records.
No, Your Lordship. And on 24/6/2025, Your Lordship, B. He was on casual leave for his personal problem, for which he applied through the WhatsApp group of the school staff. So
this can be also done. WhatsApp group to
No,
the
that
school
has
staff.
to be done.
All communications nowadays, my lord, from the department, they can send in the WhatsApp group the instruction to the school, my lord, teacher. And why not the teachers can send the my lord leave application to the WhatsApp group? Nowadays it's applicable. Mere intimation to the head of the institution is enough that I am leaving, my lord.
No,
this station.
permission has to be given because
Yes,
we have a
nodding the head, my lord, to the after listening my listening me that is enough. That
No,
everybody
your
does this.
your communication will also will not do
I have
because
given
you
the
have
written.
to be permitted.
Yes, I have given the written also, my lord. They
Yes,
have accepted and kept in the file, my lord.
formal
I have
approval
submitted
is
before
required,
the
Your
I have
Lordship.
submitted before the IS also, along with my Shoko's reply, everything I have submitted.
So that will be done in the
They have done
inquiry, Your
nothing.
Lordship.
Only
Let
to
them,
deprive me, they are doing this all.
let them get
No,
over
whatever
the
be
inquiry
it,
soon.
but then inquiry is on. But then every
Yeah.
time you raise one or the other ground, lost his years.
Okay.
Right. Then again, this inquiry will go and
He will
not
retire.
against him. Then he will retire.
That is the thing.
Right. But any decision that inquiry is not an impediment for your appointment?
There is, my lord, I've given all of my lord, the judgment, my lord.
What judgment?
The pendency issuance of the Shokos, mere Shokos.
That continuance.
Yes. And the continuous cause of action, they are harassing me continuously by.
That is not a direct decision on the point. What I want is, even if that inquiry is on, but then if he is eligible, he can be promoted or he can be appointed.
A promotion, in case of promotion, is a seal cover promotion is there, my lord. But in case of in charge, my lord, there is not like that. He can be considered even during the pendency of the my lord the departmental proceeding. He can be considered for promotion,
And your
and
lordship,
promotion
that
can be
means
given
still
in a
covered.
still cover.
and your lordship, now the regular for appointment of regular principal, that is also going on. It is on your
It
lordship.
is not yet.
The
No advertisement is issued.
process is going on. It seems.
In the department, they may file send proposal from one office to another, but there is no publication of the advertisement as on date for 2008 since 2018 in the state of Assam, except 6 schedule areas.
Okay, right. Heard, Mr. B. Purkastra. Yes, Mr. B. Purkastra. Heard, Mr. B. Purkastra, learned counsel for the petitioner. Oh, yes, respond number 4. What do you have to say?
On behalf of Anne Sharma, he is in another court, Lordship.
Achha.
Lordship, the order impugn is Lordship, it's a in charge order, Lordship.
In charge order.
Arrangement. And this is continuing. But even other also, Lordship, if we go by the rule 1235, he already crossed 57 years. So there is a statutory bar. Now, how can the petitioner now overcome that issue, Lordship? On that account also, he is not eligible, Lordship. So in the meantime, this order issued in the month of June 2025. So let the authority go for a direct recruitment, Lordship, because the post of principal should be filled up by direct recruitment. Let the authority initiate the process until then
For regular principal?
Yes. If he is eligible or I am eligible, then they have no any objection, Lordship. Even otherwise,
For regular principal also that 57 bar will come?
yes, he is not eligible. That is the main hurdle.
This type of directions, my lord, from division bench in the writ appeal number 124 of 2022 has given in the year 2024 itself to the directing the respondents to initiate the regular process of promotion to recruitment to the post of principal. They have not done anything, and since 2018 it has not been done.
After 2018, there is some selection process initiated. Principals, permanently principal position filled up. But for last 1-2 years, Lordship, the process is continuing. And because this is a Lordship, entire for the state Lordship is possible.
Next time, but then so many years.
Lordship, in view of this rule 1235, he is not eligible.
Even if we don't take that
Yes,
ground.
because by January 2025, he already crossed 57.
See, what can be done? I am with you, but then what can be done? Now you're unlucky. See, you had started this writ petitions, then those things got dismissed. You again became eligible, but then again they had started another proceeding.
Now, I was eligible in the year 2003 itself when that vacancy arose. The cause of action starts from the vacancy arose first. That day I was eligible and qualified.
2003?
Yes, 2023.
23. Now that many years have gone.
And cause of action and arose, and they have created the my lord obstacle for me by issuing one after another impugned orders. And this honorable court repeatedly, my lord, have allowed and by rejected by setting aside all these proceedings and orders. And now, my lord, at the end, if I do not get the outcome of the fruit of the litigation, it's a, my lord, that will be very
disheartening.
Yes.
But then what can you do? Rules are against you.
It is not that their guidelines says, my lord, they can give the senior most teachers, and they have given. I have given the example.
Example, they are wrong done. You cannot take shelter under a wrong
done. This is the practice they are doing. This is not the wrong, my lord.
But rule says otherwise.
The only promotion, my lord, then it's a different thing. Rule is there. Rule does not, my lord, bar them to give the appointment to the in charge to the teachers who are above 57 years. They are giving it. And their guideline, which I have issued in the year 2015, my lord, that also allows them to give that to the senior most, even without the teachers, without even the B.Ed degree they are giving.
Okay, right. Heard,
Kindly
Mr.
consider one thing, Lordship, the eligibility under the 2003 rules, that has been repealed. But it is already gone. By 2019, this 2018 Act came into force. So after 2019, my learned friend or client Lordship is not eligible, Lordship. That 1235.
But my lord, after 2019, I have given annexure 8A, my lord, and they are following that office memo guideline, and they are issuing the, my lord, orders to the teachers above 57 years, page 85, 55. This is not the wrong, this is the practice.
No, practice cannot go against the rules. Now they are going against the rules. It is for them to face appropriate thing in an appropriate case. Right. Okay, right. Heard Mr. B. Purkasa, likhila. Council for naam likhe B. D. Mushahari for the higher education, secondary education, and Mr.
A Deka on behalf of N. Sharma.
A. Deka
That's
on
now
behalf
4.
of Mr. Oboni Deka
Yes.
on behalf of respondent, on
No,
behalf
on behalf of N. Sharma,
and
he is
Sharma.
representing respondent 4. I am submitting on behalf of N. Sharma.
But then respond number 4, private respond.
Lordship, I record N. Sharma's name, madam.
Acha, did that.
Lord.
Nalage Oboni.
Yes.
And Sharma for respond number 4. Acha, there are so many facts. If I go wrong, just let me know, huh, Mr. Procrasto. By this application, filed under Article 226 of the Constitution of India, the petitioner has prayed for setting aside and quashing of the impugned order dated 21/6/2025, issued by respondent number 2, that is Department of Secondary Education, Assam, by which, where is that impugned order 21/6?
Page 45.
21.
It starts from page 44.
By which the prayer of the petitioner to appoint him as in charge principal of Sorthebari Higher Secondary School was rejected. Full stop. The petitioner has also prayed for allowing him to hold the post of you have prayed here for principal, not in charge.
In charge principal.
No, but in the prayer it is not there.
Yes,
In charge. Prayer to hold the post of in charge principal of the said school as per order dated 18/12/2023, passed by this court. Eighteen 12/23 is the order where 3 writ petitions were disposed of.
Prior to that, another petition was there. Annexure 3, my lord.
Huh? Yes.
Page 31.
By which? By which? The director of secondary education department was directed to allow the principal, to allow the petitioner to hold the charge of principal, Sorthebari Higher Secondary School, after due verification of the particulars of all the candidates in the fray. Full stop. Para. The case of the petitioner is that he was appointed as a teacher by order dated 31/3/1992, and he started getting graduate scale of pay Void order dated 30/12/1993. And that on 30th of March 2023, one Sri Jiten Chandra Borman, MA B.Ed, who was working as the assistant teacher of Hottebari Higher Secondary School, was allowed to hold the charge of principal of the said school instead of the petitioner, who was by then eligible for the appointment to the said post. Aggrieved by his non-appointment and allowing his junior to be appointed as in charge principal of the said school, the petitioner challenged, right? He challenged that.
Yes.
Petitioner challenged the same by filing a writ petition being WPC number 5419 of 2023. And this court, void order dated 18/12/2023, remanded the matter back to the Director of Secondary Education Department by directing the said authority to pass appropriate orders allowing the petitioner to hold the charge of the post of principal after verification of particulars of other candidates too, along with the petitioner, as stated above. Para. In pursuance to the said order, no, in pursuance to the said judgment and order, the Director of Secondary Education Assam, after considering the particulars of the petitioner as well as other eligible candidate, passed an order on 7/4/2024
Page 32.
কি করলো? 2024, right? Held that although the petitioner during his service period acquired the MA degree from KKHS Krishnakanta Hendricks, that university, huh? KKHSOU. And the same is a valid degree, but it was stated that the petitioner, by not obtaining previous permission from the appointing authority for that purpose, as per Rule 13 of Assam Civil Services within bracket conduct, Rules 1985, a disciplinary proceeding was initiated against him. No. A disciplinary proceeding was directed to be initiated against him. A disciplinary proceeding was directed to be initiated against him. And in view of the said fact, the petitioner was not allowed to hold the post of in charge principal of the school. The petitioner being aggrieved again, the petitioner being aggrieved again, filed another writ petition. That is writ petition number 2136 of 24, challenging the said order. And this court, vide order dated 11/4/2025, by taking up 3 writ petitions, one being challenge made to the show cause notice issued to the petitioner. The second being the challenge to the order, right?
Punishment order.
No, but third was punishment. What?
2 punishments, my lord, in the same.
2 punishments. Okay. And the second being the punishment imposed upon the petitioner. And the third, also in relation to punishment imposed on the petitioner.
Show cause.
Huh?
Show cause.
Show cause was first, I said.
2 writ petitions, 2 orders put to challenge in 3917/2024.
Wait.
2 punishment order, 10/7/2024 and 11/7/2024.
So one is 2 is punishment, 2 are punishment orders, 1 is show cause. Yes, this is what I said. The ki kolo last word? Upon the petitioner disposed of the said writ petitions by setting aside the show cause notice and the resultant punishment orders,
Including the order of the director.
including the order of the director
7/4.
dated 7/4/2024. Let me see what are these writ petitions against. It first, second will je kolo. One being so and so. One being, one being the order dated 7/4/2024. The second being a show cause notice issued on 19/4/2024. And the other being the punishment of warning imposed upon the petitioner by order dated 11/7/2024. Hekin katiye diba, huh? 11/7/2024. That's set aside column, set aside the charge along with the charge, the punishment inflicted as well as the order dated 7/4. Tinta hai. punishment inflicted, and the order dated 7/4/2024. Para. What is this 19/12/23 order which was not interfered with?
But this is a guideline, the common order issued by the director, my lord, whereby the director has given a direction to the all IS of the state that wherever you will find that teachers are not taken the NOC, you issue the disciplinary proceedings, the blanket order to all. On the basis of that, the IS is authorized to issue the disciplinary proceedings against all those teachers of the schools who have procured the degree without the NOC.
This court, on the ground that not obtaining the prior permission, from the appointing authority being the reason for rejection of his claim for appointment as a in-charge principal, can only result in initiating the departmental proceeding and not in rejecting the claim of a candidate for his appointment as an in-charge principal. This court, by the said order, dated 11/4/2025, had, however, not interfered with the communication dated 19/12/2023, by which a direction was given to initiate departmental proceeding against candidates who had not taken prior permission, as stated above. That is the fact, right?
Yes.
After that, what happened? They had, after, yes. Thereafter, thereafter, in compliance of the High Court's order, no, we don't know. No, praying for allowing him as so and so. Thereafter, the petitioner, it will order date to kiman ase? 24/4, right? No, High Court order to kiman ase? 11/4. Okay. Thereafter, the petitioner, on 25th of 25/4/2025, filed a petition before the, he filed the petition before the Director of Secondary,
Yes.
filed before the Director of Secondary Education, Assam, praying for allowing him to act as principal in charge of the school. And the Office of the, and the Director of Secondary Education, Assam, by order dated 21/6/2025, wait, let me read. In compliance of the High Court's order, had held as follows. In view of, full stop, in view of order dated 18/12/2023, Hearing was conducted by the Joint Director of Secondary Education, and a speaking order was passed. No, it will in compliance of the right 18/12/2023 in view of the earlier order dated qua. Earlier order dated 18/12/2023, a hearing was conducted by so and so, and a speaking order was passed on 7/4/2024. This was before the order, you see, for initiating departmental proceeding.
This is my lord, before the order.
Yes, before the order. Speaking order dated 7/4/2024 was passed, directing the Inspector of Schools, Borpeta, to draw this departmental proceeding against the petitioner for misconduct, for violation of Rule 13 of Assam Civil Service Conduct Rules, 1965. And that in the place of the petitioner, one Jiten Bormon was allowed to continue as principal in charge, as stated above. Full stop. It was further observed that Rule 12(3)(5), 3 within bracket, Roman 5 within bracket, of the Assam Secondary Education Provincialized School Service Rules of 2018 provides that if the age of the candidate is more than 57 years on the 1st January of the year, on the 1st January, then he shall not be considered for appointment as a principal of the said school. Full stop. In case of petitioner, it was observed that his date of birth was 1/3/1967, and by calculation, the petitioner would be 57 years and 10 months on 1st of January 2025. And due to this inability, or in other words, for non-fulfillment of the criteria, the claim, the prayer of the petitioner for allowing him to act as principal in charge of the said school was rejected. And in place of the petitioner, respondent number 4 was temporarily allowed to act as principal in charge of the said school. Para. Agreed by the same. And agreed by the same, he has filed 2003 writ petition.
No, no, madam. This is the instant.
This is ACR.
Yes, yeah.
And this is the instant petition.
Yes.
Right. Agreed by the said order. Allegedly agreed by the said order. Dated 21/6/2025. The petitioner has filed the instant petition challenging the same and to allow him to be appointed as the in-charge principal of the said school. The learned counsel for the learned counsel for the petitioner submits that the petitioner became eligible for appointment as an in-charge principal of the said school in the year 2023. He having not completed 57 years of service. 57 years of age, not completed 57 years of age. But the respondent authorities have not allowed on one ground or the other. First being, his not obtaining the prior permission from the authority. While acquiring his BA degree, MA degree, while acquiring his MA degree in the year 2016. For which Ashoka's notice was issued and the punishment was imposed by the department. But the same cannot be an impediment. Department full stop there. The learned counsel further submits that non-obtaining of the previous sanction cannot be an impediment for appointment as a in-charge principal. And as such, this court, wide order dated 18/12/2023, directed the Director Secondary Education Department to consider his case. No, when this order was passed, the punishment was not imposed, right?
Not it.
That order was passed only making him ineligible.
Yes. IS has been directed to issue the departmental proceedings. IS is directed to issue departmental proceedings.
সেইটো যে দিলো যে হেৰি কৰিবা, this court, not 18/3, this court had set aside 18 order to nalage. One or the other বুলি কলো no. The নহয় সেইটো তুমি আকৌ লিখাছো নকমা, this one I'll amend. One or the other reasons দিলো, he has stated that one or the other reasons the things were at the first instance, when the junior to the petitioner was appointed as the in-charge principal of the school and the petitioner was not given, a writ petition was filed, wherein this court, by order dated 18/12/2023, had directed the Director to Secondary Education Department to consider the case of the petitioner as well as other candidates. Full stop. The petitioner, however, was not considered, and a new ground that the petitioner did not take permission from the appointing authority while obtaining his MA degree from so-and-so university, from so-and-so university. And the said decision and the said order was put to challenge by the petitioner in yet another writ petition. And this court, by order dated 11/4/2025, had set aside the charge sheet, the impugn order, as well as the punishment inflicted upon the petitioner. And then again, a new ground was taken up by the authorities concerned. That is, petitioner is not eligible since he has completed 57 years of age, was again not considered for the post of in-charge principal. The Learned Counsel further submitted, and this leave is a new ground during pendency of this, right? Further submitted that during pendency of the instant writ petition, the respondent number 2 has filed an affidavit in opposition raising a new ground that petitioner had signed the affidavit on 4/4/2025 as well as on 24/6/2025. By coming down to Gauhati for filing the writ petitions. And that in the attendance register, the petitioner was shown present in the school. Finding this alleged irregularity, show cause notice was again issued to the petitioner on 5/1/2026. When was the order given? 5/1/2026, right?
Yes.
And that order was given out on which date? 21/6. That was before. Order was before. Show cause notice on this ground was earlier to the order where 57 years was taken as a ground, was earlier to this order. But in this order, that leave thing was not taken into account.
Yes.
This is a new development that they came to know.
Further.
Hearing was conducted.
After filing of this case, my lord.
After lodging here,
After filing of this petition, my lord.
After filing of this writ petition,
Yes.
show cause notice was issued when? This
It was-
January.
Yes, this January.
This January 26.
Yes.
Or writ petition was filed in 25. No, what I mean to say is before this order,
Impugn order.
impugn order,
Impugn order, my lord, it was issued on 21/6/2025.
25, okay. This was after.
In the year 2026.
But why these facts were not known to you before?
Also because we had filed WPC number 2003/2025, there was a stay, your lord.
Acha.
After it was pursuant to this, your lord, a hearing was conducted. Because there.
But before disposal, no, no.
We had challenged the ACRs and all,
Mm.
their hearing was conducted. When the hearing.
Yes, here they have submitted.
Mm. Okay, during pendency colon on 5/1/2026, right? The department had also given the statement of allegations to the petitioner on 5/1/2026 itself. The learned counsel for the petitioner therefore states that
My reply will be quoted on page 75.
what is the reply to this?
Reply on page 75, 75 para.
Hmm.
75 to 77 I have given, madam. Entire reply, so-called reply quoted in the affidavit reply.
No, that is a show cause reply. But this raising of new ground, what did you say?
Because, my lord, I have clearly stated, my lord, that on 4/4/2025, I have taken, on both the
Acha,
dates,
acha.
I have
Okay,
taken permission.
Learned counsel for the petitioner submits that he had not taken leave on both the dates.
On one date.
On 2 dates, they have said no.
Yes, in one date, my lord, I have not taken leave. I have
That
come
he-
after school.
That he had not taken leave on 4/4.
Yes,
On 4/4/2025.
yes, come in the evening.
And that after school hours, he had come down to Gauhati
Yes.
for signing the affidavits. And what about 24/6?
On that, they have taken CL, casual leave.
Full stop. He further submits that on 24/6/2025, he had obtained a casual leave through the WhatsApp group,
It is recorded in the attendance register itself.
which was recorded in the attendance register itself. And as such, he submits that there was no cause of action against him, as stated by the respondent. He therefore further submits that the respondent has taken one or the other plea to reject the candidature of the petitioner. It is although submitted by the learned counsel for the petitioner that the petitioner became eligible in the year 2023 itself, when he had not crossed his 57 years of age. But by the various orders passed by the authorities concerned, years have gone by and he became ineligible by virtue of Section 12
Rule 12.
or Rule 12, 3, Roman 5. But the same cannot be taken be considered, cannot be considered for his appointment as a, there is no way out. We'll have to dismiss this matter. Because he became ineligible. Yes, of course, years have gone by.
So in
And your eligibility got
2019.
washed away. But then what can we do? Now you're not eligible. Now 57 years have crossed. 12.5, how can I surpass? Even if somebody else was done. That is what they know. Somebody else will come and challenge that. But in this proceeding, how can that be? You are unfortunate. Right. Even if your show cause notice gone, your punishment goes in view of that earlier High Court's order. That time also you could have been appointed. Again, some new ground they had taken. But then that ground fits into your 12.53, 12.35. We will not go into that leave and all. But 12.5 does not come to your rescue.
In that case, my lord, cause of action, if we take from the day of 2023, then it rescues me. Otherwise, if the cause of action.
That decision is also not very effective, not very convincing. That is a continuous cause of action in view of the petitioner side. But here, your regions are different.
Reasons are different, my lord, but my deprivation is continuous.
Anyway, I'll think over and I'll pass the rest of the judgment in the chamber.
Obliged.
If I can get some clue.
My lord,
Yes.
Lordship, my lords, I seek to mention item 49, if my lords
49.
may allow. I was not able to make the mention early in the morning because I was on my legs in another court. My lords,
Death, I think. Oh no, that was a different matter. Okay.
my lords, I seek to withdraw the petition because it has become infructuous.
49.
49, my lords.
The main list.
Yes, my lords.
Huh.
Because
Both
the
I and the contempt. Oh,
Yes.
I is for what? Condonation.
condonation of delay, but like the underlying order was challenged in a writ appeal, and the writ appeal has been allowed. So our contempt has become infructuous. So we seek to withdraw and.
Give any reason simply that you are withdrawing.
Sure. And my lords my lords may be pleased to note that we be granted liberty to pursue action in a different.
Anytime.
Yes.
What happened? You had your order before the single bench, but then it was set aside.
No,
by
it
the
was
division bench.
challenged in a writ appeal.
And it was set aside by division bench.
It was not set aside. It was allowed.
No, Lordship, I would want to interject here. The writ appeal was allowed, and by the order of 28th April, our underlying order in this contempt has been set aside by the writ appeal
The
court.
order has been set aside. The appeal has been allowed. Yes, that's what I said.
The order was set aside.
Yes.
Yes, yes, yes.
That's why your contempt has become infructuous.
Yes, ma'am.
Yes.
So there no contempt lies rather.
Yes, ma'am.
Yes.
Okay, your name please?
S. Barwa.
May I heard Mr. You are with
Hemant Gupta.
S.
Yes,
Barwa and
yes,
Hemant
yes.
Gupta, H. Gupta.
Okay, write the names, sir. Learned counsels for the petitioner and as well as oh, your contempt case. You're for some other matter. Acha, so and so for you, who submits that the contempt application had become infructuous in view of the fact that the order passed by the learned single judge was set aside by the Honorable Division Bench in the writ appeal filed by the department. Right? Department?
Yes, yes.
Department. Full stop. In view of the same, the learned counsel submitted that he has instructions to withdraw the matter as the same has become infructuous. Prayer is allowed. Matter is closed. With a liberty.
With a liberty.
With a liberty. What liberty you'll have? This is set aside. If so, you go to Supreme Court.
Yes, yes, your lordship. We will be
With a liberty to file afresh. With a liberty to file afresh. Matter is closed.
I was very much obliged and apologize. I apologize for not mentioning it today morning.
Okay.
My lord, in regard to
much obliged.
item 2, I pray for the adjournment. We need to file a wakalat, my lord.
Which matter?
Item 2, which has been passed over for time being. Item 2.
Item number 2?
Yes, my lord.
That was passed over for time being?
Yeah, my lord. I pray for an adjournment. We need to file a wakalat, my lord.
Time being, it will be called again?
My lord,
Mr. S.S. Roy appeared?
Yes.
You are also for respondent?
I'm for the petitioner.
You go to say. I get confused otherwise. Acha, you want what?
I need some time to file my wakalatnama.
What, it was just simply passed over for the time being?
Passed
On
over
what
for
ground?
the-
She was not there.
Yes, Lordship.
Oh, acha, she was not there. Okay. Because I was searching for R. Majumdar, right? Yes. So, right? Heard Miss T. Wapangla, Learned Counsel for Petitioner, and Mr. S.S. Roy. He said he will go.
Yes.
Mr. S.S. Roy, Learned Assistant SGI. Miss Wapangla submits that she needs some time to file affidavit in opposition.
Along with wakalatnama. Reply.
Affidavit in reply.
I need to file a reply as well as to file
Acha,
wakalatnama.
she needs some time to file her wakalatnama as she has been newly engaged in this matter and would also like to file an affidavit in reply. Prayer is allowed. List this matter when?
First week of June.
List this matter on 5th of June, 2026.
Affidavit in opposition.
Okay. Why 4 weeks? 2 weeks would be
Lordship,
sufficient.
will instruction from LICI.
LIC headquarter.
Yes, Lordship.
Okay. Heard Mr. A.R. Bhuya, Learned Senior Counsel, assisted by Miss
S. Loskor.
S. Loskar, Learned Counsel for the petitioner, and Miss
R. Bharali.
R. Bharali, Learned Counsel for all the respondents. Miss Bharali submits that she requires some time to file her affidavit in opposition. Prayer is allowed. List this matter on when? June. On 8th of June. Okay? Is it okay?
Okay. Much
1 month only. 8th of June.
But
Yes, Mr. Chetri.
May I please, your lordship?
Hmm.
My lord, lordship will say the order dated 24/4/26, passed in IA 11911. My lord, the order here 24/6 as filed for amended cost title, my lord, by inserting the inflated come before the proceeding. The petition is for claiming of the deceased husband's provident fund by the petitioner. Now this respondent number 3 is to be called for by saying notice and
So-
to be heard in the proceeding.
Okay. So you had filed your amended cost title and all?
Also the record.
R3, okay, issue notice to R3 today?
R3, madam.
You are for?
I'm
One
for
and
the
two.
petitioner.
1 and 2.
For the CV.
Okay. Heard Mr. KD Chetri, Learned Counsel for the petitioner, and Miss
Are they appearing on behalf of SS Roy?
R. Dev, appearing on behalf of SS Roy for respond number 1 and 2.
1 and 2.
Issue notice upon newly impleted respondent,
Number 3,
that is respondent number 3,
Srimati Rekharani Das.
by speed post with AD as well as by usual process. Returnable by? Returnable by 1st of June?
1st of June.
Yes.
First week of June. Date may be fixed, madam.
So 1st of
Fourth
June, I
week-
said 4th of June.
4th of June.
4th of June. Okay. So there was interim order.
Yes, sir, interim order passed earlier, madam. That
Interim
may
order
continue
passed
by
earlier by this
27
court
to 25.
shall continue till the next date of
Till
listing.
the next date of listing.
Yes, I said
Madam,
till the next date of listing. Okay.
with all respect, madam. Great respect, madam.
Lordship, item 21, we have not received any instruction till date, Lordship.
Acha, what instructions?
There.
Personal matter, my lord, actually second round of litigation. After issuance of notice for the first time later, this matter is statement.
So extra copies were also given to you?
Everything is given. There was a communication, Lordship. They asked for some time, Lordship. I think there was the listing of the matter also for a long time, Lordship. That's
This
why,
was,
Lordship.
yes, September 25.
Yes, Lordship. In September, there is a communication, Lordship.
Acha, you bring the necessary instruction then?
Lordship, Lordship.
Okay, Mr. Sharma, right?
Yes.
Mr. J. Sharma.
Yes.
Heard Mr. J. Sharma, Learned Counsel for the petitioner, and Ms. M. Bhattacharjee, Learned Counsel, Learned Government Advocate. Learned Additional Senior Government Advocate. No.
1 and 3, Lordship.
That is for respond number 1 and 3. Ms. Bhattacharjee submits that she is yet to receive the necessary instructions and has prayed for some time. although communications were made long back on 8/9/2025. Oh no, the communications were made
It was
long
in
back.
October last
That is
communication.
pursuant to order dated 8/9/2025.
Lordship.
But she requires some further time to get the entire instructions. Prayer is allowed. List this matter after 2 weeks.
No, Lordship, 3 weeks.
List this matter on 5th of June,
Lordship,
2026.
deeply obliged.
22.
Health and family welfare, 3 weeks time to file affidavit in opposition. What happened?
Yes, your ladyship, it has been, the affidavit has been sent for vetting. We'll file it by tomorrow, your ladyship.
You have given him a copy?
Uh,
No. Yet, not yet.
We'll get it.
Okay.
Any day
Heard
next
Mr.
week.
P. Boiragi, learned counsel for petitioner, and Miss
R. Sharma, on behalf of Standing Council, D. Upamanya.
On behalf of Standing Council,
Health
Health and Family Welfare Department, Mr. D. Upamanyu. Miss, what did you say?
R. Sharma.
Miss R. Sharma, learned counsel, submits that the affidavit has been prepared and the same has been sent for vetting, and that she submits that on receipt of the same, she would immediately file the said affidavit. And as such, she requires some time. Prayer is allowed. List this matter on 25th of May, Monday, 25th of May, 2026. Yes, Miss Jia.
Dismissal from service, your lordship response.
May please, Lordship, this matter is basically challenge in regard to the outcome of the disciplinary proceeding and the appeal, Lordship. Also, we have received the previous comments, Lordship, and we got some time to file our affidavit, Lordship.
Acha, so you are for some department?
Yes, I'm appearing for all the respondents, Lordship. Basically, we have received the previous comments on behalf of respondent number 4.
Acha.
Department of Home.
Okay, heard Miss S.S. Jia, learned counsel for the petitioner, and Mr.
PKS Barua.
C.K.S. Borua. C.K. Sharma Borua. Same name, like your father. C.K.S. Borua.
Yes.
Learned counsel for respond number?
All the respondents, Lordship.
For all the respondents. Mr. Borua prays that he may be allowed some time to file the affidavit in opposition. Prayer is allowed. List this matter after 2 weeks. List this matter on 29th of May.
Lordship, Lordship.
Right? Friday.
Obliged.
24.
Yes, Mr. Saikya.
This matter relates to payment of pension, my lord.
No affidavit till date by any of the parties?
We have sent the affidavit for swearing, although it is not yet received. But as per my instruction, your ladyship, the petitioner here is not a minor child. Only a minor child is entitled to receive 2 family pensions. Here, my ladyship, the petitioner is an unmarried dependent daughter, and that category will not receive 2 family pensions.
Only one?
Only
yes,
one.
only one only, I believe.
Does the department?
Is it? Okay, let her file affidavit. We will look into the entire matter. Heard Mr. I.H. Saikya, learned counsel for the petitioner. Last time only you were supposed to bring some communications. Respondents, more particularly 6, will complete his instructions and apprise the court in respect of communication dated 21. Anyway, you file your affidavit.
Yes, Your Lady.
Bring in to record all those.
Yes, Your Lady.
And Miss?
U. Sharma.
U. Sharma?
For respondents 3 and 6.
3 and 6. And you are appearing for B? B. Chakraborty. And Miss? A. Sharma. Learned counsel for B. Chakraborty, learned counsel for Accountant General. Ms. Sharma prays that she may be allowed some time to file the affidavit on behalf of the said respondents. Prayer is allowed. List this matter. When can you? Everything is over.
Everything is ready. But
so
just
list
was
this
very-
matter on 20. 5th of May.
May I please, Lordship?
Hmm.
Lordship, I on behalf of my senior, Rafiq, my lord, on date 7/05/2026, we received affidavit in opposition. Thus, seeking for a short time accommodation to file affidavit in reply before Lordship.
Oh, you want some time to file affidavit in reply?
Yes, my lord.
And who has filed AO?
We have filed, Lordship.
You
We
have filed.
Response number 3.
Respond number 3. Okay. Mr.
Compensate Yandan.
Homben Z, so-and-so, appearing for Mr. I. Islam. Submits, I. Rafiq submits that he requires some time to file the affidavit in reply in response to the affidavit in opposition filed by respond number 3. Prayer is allowed. C.K. Sharma Borwa appears on behalf of respond number?
All the respondents.
All the respond, on behalf of all the respondents. List this matter again on, how much time you want? List this matter again on 3rd of June.
Yes, ma'am.
No, sir.
Item number 26, 53, 54, and 55 are similar.
Similar matter.
I am praying for 4 weeks time to file reply.
File reply?
Yes.
To the AO. Filed by?
Respondents, for all respondents.
All respondents. One is additional affidavit by you. And the other one is AO by 1 to 6. So there you want to file reply. Okay. Heard Mr. S. Alam, Learned Counsel for the petitioner, and Mr. A.K. Dr. CGC. Learned CGC. Mr. Dr. Submits that he requires some time to file the affidavit in reply to the affidavit in opposition filed on behalf of respondent number 1 to 6. Prayer is allowed. List this matter. When do you want?
After 4 weeks.
4 weeks. List this matter on 8th of June.
Well, the other two cases also similar.
Oh, yes. What are the other men? They're also same. You have to file affidavit in reply.
Yes.
Acha, then same in item number?
After 8, Lordship. On 8, I have some.
Acha, so then 10th? On 10th.
Items for 53, 54, and 55.
53, 54, 55, huh? Supplementary.
Lordship, in all cases, there is interim order.
Acha, interim order is there?
Yes.
54. No, 54.
Interim order passed earlier shall continue until the next returnable date. In all the matters, huh?
53, I'm appearing for you.
Oh, 53, you write SK Medi for the CGSC. And Ms. Bijita Sharma?
52, but petitioner council is another person, another council for petitioner. But issue is same.
Acha, 54.
52.
52 likha, heard Miss?
PP Das Lordship.
PP Das on behalf of TJ Mounta? No.
Mr. PP Dr. Lordship.
Acha, PP Doctor, Learned Counsel for the petitioner, and Ms. Bijita Sharma, Learned CGC. Rest of the things will be same. You will file your affidavit in reply?
Yes, sir.
Acha, rest of the things are same.
Interim order.
Interim order? Yeah, I'll extend it till the next returnable in all the matters. 10th June. And what about the other 53, 54, 55?
53.
Acha, ठीक है, एटू दीजिए. You are in 52. 52 diba, हाँ एटू.
52 we filed our counter.
50?
We'll file 53 affidavit operations already filed.
In item number?
53 we file affidavit.
53.
Yes.
53, you are there. CGSC has filed affidavit. No, he wants to file a reply.
Your Ladyship, here I have received one communication from the Joint Secretary, Labor Welfare Department. They are seeking for some more time to furnish the pair-wise comments.
You are Miss?
R. Bharali, Lordship.
R. Bharali, Learned Counsel. Heard Miss R. Bharali, Learned Counsel for the petitioner. And Miss Sharma.
U. Sharma.
U. Sharma, Learned. You are for?
For 1 and 2.
1 and 2. You are government advocate, right?
Yes, Your Ladyship.
Learned government advocate for respondent number 1 and 2, and you?
43, Lordship.
Respond number 3.
Yes, Lord.
Respond number 3, I say services complete, that means.
Yes, Lord.
Miss
Peace all.
P. Sohoria, learned counsel for respondent number 3. These are the respondents or there are more?
These are the respondents.
1 to 3. Okay. Miss Sharma, learned government advocate, prays for some time to file her affidavit in opposition or to get her
Pairwise comments.
or to get her proper instructions.
Lordship.
Prayer is allowed. List this matter after. List this matter on 5th of June. Yes, Mr. Sharma and Roy.
Chalo, the case, my friend has to make BSF as a party respondent for getting instructions. So he had not made. I've been informed.
It is for the petitioner side whom to implement and whom to not.
Here, my lord, SSC conducted a selection test for appointing some armed police person.
Trustable.
Yeah,
No.
armed constable.
CAPFs.
Central Armed Police Force, it is called. Includes CISF, BSF, Assam Rifle, etc., etc. I applied under this economically weaker section category. I got selected. There were 3 rounds of selection procedure. Written I cleared, medical I cleared, and document verification, everything I cleared. Well, there are 59 posts reserved for economically weaker sections. I qualified. They have filled up only 2. I was not called. So as 57 left vacant. So I filed this petition saying that I may be called for. Well, they were supposed to take instruction, but as my medical test and document verification was under that BSF, I have not made a party, but I made Ministry of Home Affairs and all announcement of who was the
BSF as a
nodal
party
officer. I
to
made
get the
party him
instruction.
also. I can make a party. Only thing is that, my lord, I have some urgency because if the time goes, my right to get appointment will also vanish, my lord.
They have made appointment only to 2 posts.
Yes.
Lordship, let her.
Only 2 posts from economically weaker section category. That is, my lord will kindly see at page 7. I have given it in a tabular form. Page 7.
Acha, what about your impleading BSF as a party?
He has to implement, my lord. Otherwise,
BSF has conducted the medical test, as my learned friend says. But this respondent number 4, Director CRPF, he is the nodal officer of this test doing. I have made Staff Selection Commission is also party, and everything is under the Ministry of Home Affairs, Defense. I made a party. I don't know, my lord, they can take instruction, but if required, I will make a party. No problem in that.
But then according to him, BSF is not a necessary party.
It is a necessary party because as per page 12, Lordship, as per our recruitment policy, does the verification, he has to be party. Otherwise, where from I will get the instruction? BSF, in all the cases, the person who does the document verification, he has to be a.
But he said that only medical part BSF.
No, Lordship. Kindly see, he is not, kindly see 1.9 in the examination notification, Lordship.
1.9.
Yes, page 12.
Yes.
Court cases, RTI, public grievances relating to the conduct of the computer-based examination, preparation of merit list, force allocation of selected candidates, and final result will be handled by the SSCs.
This is
Staff Selection Commission. Thereafter, Lordship, and the issue relating to the other matters, namely policy-related issue arising in the examination, scheme of the examination, vacancies, conduct of PST, PET, DME, detailed medical examination, RME, review medical examination, document verification, etc. will be handled by the MHA, the coordinating CAPFs. The coordinating CAPFs is the BSF.
CAPF means?
Central Armed Police Force Services.
This comes under MHA, Ministry of Home Affairs.
Ministry of
BSF comes under MHA.
MHA, but the coordinating is BSF.
CAPF and BSF are same.
Constable, Lordship.
CPAF and BSF are same.
CAPF is the constable in Central Armed Force, CAPFs, and this recruitment process, page 11, Lordship, the advertisement. Constable GD in Central Armed Force, CAPFs.
Central Armed Force.
Lordship. BSF is one of the unit of that. CRPF is one of the unit. CRPF is the nodal officer of SSC. And thereafter, if relating to that document verification, PST, PET, the coordinate CAPF has to be
It
looked.
will be handled by MHA.
MHA.
MHA is home.
Ministry of Home Affairs.
Ministry
and
of-
coordinate-
That he has made.
And coordinate.
Slash.
Slash.
Or. Means
Coordin-
or.
Oh, yes.
Or the coordinating
At
CAPFs.
Coordinate CAPF is the BSF authorities, Lordship.
Uh,
He has to meet different parties,
BSF is a part of CAPF.
Lordship.
My lord, the respondent number 4 is the nodal officer to conduct the under him only edition of Azara, whatever is there. So my medical was conducted there. So as per my learned friend, I have to make this particular, I'll make it, my lord, no problem. But it says, my lord, point 1.9 at page 12 as my learned friend says, this says, my lord, I'll read it again after SSC. And the issues relating to the other matters, namely policy related issues arising from the examination, scheme of the examination, vacancies conducted.
Vacancies there.
There is the.
Then document verification.
There.
Passed all these things.
Well, then he had not annexed any document that he had cleared document verification.
No, yes.
But then he will be questioning your entitlement.
Yes.
He will be questioning that your documents are not proper.
Page 42. Page 42.
But vacancies, it's there.
No, my lord, I have the document. There is a certificate, page 42, annex 3.
42.
Yes.
Yes.
Well, this is my document, name of the petitioner.
This
Is
is
there.
the-
This
Whether
is,
it was verified or not.
yes,
Lord-
verified, qualified, I mean, medical
Yes.
test.
Where is it reflected?
My lord, this,
Candidate detail is you, Rokibus Jaman.
yes. That's the
And
petitioner.
then,
My lord, this allocation details scored in the computer-based examination, this is written. Then status of height says this is PET, PST. Status, my lord, I have qualified on the right-hand side. Document verification status, DV. On the right-hand side, I have
qualified.
I have qualified, my lord. I have
No,
given
but
the-
as far as vacancies are concerned, this is also under
vacancies
CAPF.
are, notified in the advertisement. That is, my lord, at page 7. This is notified in the advertisement. I can show from advertisement also.
But vacancies are there, Lordship.
Vacancies are there, no dispute
That's-
about that. These are vacancies.
How
My lord,
the
kindly see
allocation-
page number 7. This is for state of Assam. Reserved forces are, my lord, Assam Rifle, BSF,
7.
page 7. Of my
Yes.
petition. BSF, CISF, CRPF, ITBP and SSB. These all comes under the Central Armed Police Force, CAPF. Well, for Assam, category EWS, 1 vacancy is there. They have filled up only 1. Okay. BSF 17 vacancies filled none. CISF 19 vacant. They notified, my lord, this vacant position. They have filled none. CRPF 18 they have notified, filled up none. ITBP 3 none.
But
filled up.
in the case of instruction with regard to the vacancies,
No, no.
he might require some instructions.
Yes.
Yes, my lord.
Why this
Right.
was not.
Why
filled
they
up-
have not filled up?
Not filled up.
But whether, why it is not.
Because
that
whether
is-
there is a court case pending or not, that also we have to look into.
No, my
Lordship.
lord, what I am saying, correct, my lord, he is correct. He has to get that instruction, why you have not filled up those 15 checks. But for that, whether the authority who has conducted the test, they will be a necessary party. Well, it is ultimately MHA, Ministry of Home Affairs will give me the appointment or not.
But slash CPA,
Make him a party. I
Right.
can do it. Well, I'll, in that case, I'll pray for a short
Yes.
test.
very short date.
Yes,
You file your impleading application, we will allow, we
Thereafter.
file it day after tomorrow.
yes, why is that?
Okay. Heard Mr. TR Sharma, Learned Counsel for the Petitioner, and Mr. S.S. Roy, Learned CGC.
Lordship.
CGC. Mr. Sharma submits that under the notification, where was this? 12 point so and so?
12.
Page 12, right? Under the notice dated 5/9/2024, it appears that the issues relating to document verification as well as vacancies. No, document verification as well as vacancies and other related issues. The same was the responsibility of MHA or the coordinating CAPFs.
That is, my lord, BSF Padgaon.
CAPFs. As such, he submits that he will file an impleading application for impleading the necessary party, that is BSF, in the area of respondents. Prayer is allowed. List this matter day after tomorrow.
No, my lord, on day after tomorrow, I will file it. Lordship will kindly allow listing it on 18, my lord, next Monday.
Okay. List this matter on 18th of May 2026.
I'm obliged.
Item 51, something.
May I please your ladyship?
Hmm.
My senior, he is on legs, lordship. Kindly pass over for the time being, lordship.
Time being. You are for Mr. Biplab Chakraborty. Okay. Or you have some prayer.
Okay. They may be submit the reply, lordship.
Wait. Let me see the last order.
9 January.
Our respondents are directed to file affidavit
Uh,
on or before 30th of April 26.
Yes, lordship.
And liberty was given to the petitioners to file reply. They have not filed affidavit.
Not filed.
Lordship, we will file our affidavit.
Okay, let Mr. B. Chakraborty come.
Yes, lordship.
Right?
Item 29.
There is an affidavit by somebody. A to 7,
Lordship,
1 to 7.
1, 2, 3.
1 to 7 affidavit is there on record.
Yes, lordship. Lordship, we
1 to 7. 1 to 7 are the parties. An affidavit is filed. You file your reply. Okay. So let him file a reply. Heard Mr. A. Karim. Heard Mr.
Double R Karim, lordship.
Double A. Karim, learned counsel for the petitioner, and Miss Sharma. A. Sharma. A. Sharma, learned counsel appearing for Mr. B. Chakraborty, learned CGC. It is seen from the records that affidavit in opposition is filed on behalf of respondent number 1 to 7. And Mr. A. Karim, learned counsel for the petitioner, prays that he may be allowed some time to file the affidavit in reply. Prayer is allowed. List this matter when?
3 weeks, lordship.
List this matter on 8th of June, 2026.
Interim order may kindly continue.
Interim order is there.
Lordship. And January.
No coercive action. Interim order passed earlier shall continue till the next returnable date.
Lordship.
29, 30, bail hearing.
29th. What is this bail hearing in midst of pension, suspension, all these matters? Huh?
Your lordship.
No PP today? You inform? Some PP to be there, we'll take it up after some time. There is yet another bail hearing. By you?
29,
Oh no, Mr. Chaudhary is there.
31.
He meant 31 years.
All right, 29, 30.
Neto pisar ho bolo. Oh, PP is not there, no? You call him. Let a PP come. All of laughter sometime.
32, 33. All of us.
Yes, why has it come up for orders today?
In WPC 7626, we have implemented private respondents. They were not implemented, my lord. Subsequently, they have implemented. I think my friend has appeared for some of the respondents.
I appear for 5, 6, 8, 9, 12, 13, 14, 15, 16, and 17.
So why not the in-between people? You appear for all?
As regards
stuck in between somewhere. Just get stuck somewhere.
They
and
couldn't
as
find
regards
you.
respondent number 18, there is an office note, my lord, which reflects that the addressee, no such addressee found. But we have taken issued notice in the address provided by the department only. Therefore, I may be permitted to take steps upon respondent number 18 through the departmental.
18?
18, my lord. There is a Lavajima court order, my lord.
Through respond number 2?
Yes.
Okay,
director.
you take that notice then.
Yes.
And what about other part? All others
they
are
have been served.
represented.
That notice reflects, my lord, that order, Lavazima.
All others are
All
represented.
others are.
Only 18 is left.
18 is left out.
I am appearing in the second writ petition for the respondent number 4.
Acha, let me finish this.
Not yet.
7626. So there was no alternative address, right?
No, madam.
Acha. Okay, heard Mr.
E. Chakraborty.
B. Chakraborty, T. Chakraborty, learned counsel for the petitioner, and Miss Das.
No, I am appearing in the second writ petition, Lordship.
Oh, acha. And Mr. M. Das, learned counsel appearing for respondent number 5, 6, 8, 9, 17. Why 17 in between?
12, 13, 14, 15, 16.
Naruba. 5, 6, 8, 9, 12, 13, 14, 15, 16, 17. 12 to 17. So what happened to 7, 10, 11?
7, 10, 11 has been served. The report, previous report of the Lavazima court may kindly be perused.
Earlier report.
Yes.
7, 10, and 8.
Yes.
7, 10, and 18. 7, 10. What
7,
about
10 has been
others?
served, 18 has not been served.
11 also not, cannot be served. Or may have
11, what happened?
11 or 9.
Except 18, my lord, everything. Notice has been served.
Served, right?
Yes.
Okay. Okay. So Mr. T. Chakraborty submits that he may be allowed to take fresh steps of service of notice for service of notice upon respondent number 18 through respondent number 2 as reflected in the order in the office note dated 1/4/2026. Recorded by the Lawajima court. Prayer is allowed. It is further seen that service of notice is complete upon all other respondents. Accordingly, list this matter on fresh notice.
Any date, ma'am.
List this matter on June. List this matter on 10th of June, 2026. What about the other matter?
Both are connected, my lord.
Both are connected, Lordship.
Sorry to file your. This is in respect of 7626, huh?
Can it
This is also 18 is not served.
No, 18, there is one private respondent that has been.
I am representing Lord.
Lordship, other matter, can it be on 12th of June?
When can it be?
12th of June.
12th.
Instead of 10, can it be 12?
Acha, there, make it 12th of June. Here, what has to be done? Same.
No, but it has to be tagged along with that, my lord, because
Okay.
both are connected matters, my lord.
Heard Mr. T. Chakraborty, learned counsel for the petitioner, and Miss
M. Devi, Lordship.
M. Devi, learned counsel appearing for respond number
4.
4. You are not there? No, respond number 4. As prayed for by the councils for the parties, list this matter on 12th of June, 2026, along with the other writ petition.
Obliged.
Yes, Lordship, on the last occasion, I filed an application for the amendment of the cost title, including this SCRT as a party respondent in this case, and accordingly it has been allowed, and I served a copy to the council for the other side also. And I had also informed him about the listing of this matter because.
Impleading is done.
The impleading has been done. I
Amendment
served
cost
it-
title file.
Yes, cost title. cost title-
On the main, on the cause list, the name has not been reflected.
Exactly, Lordship, I had
Perhaps,
informed him. the-
perhaps, my lord, the SCRD council is not aware, my lord.
No, he is aware. I've informed him when I have sent this message with regard to the listing of these matters. He is aware of the fact that this matter has been listed. So can it be taken up day after tomorrow, Lordship? There is some urgency in the matter. Pension related.
If the other party is ready, I can always take it up.
Yes, Lordship. Day after tomorrow, Lordship.
Day after tomorrow.
I am for elementary. The SCRD council, I'll inform, my lord.
SCRT.
SCRD council, I'll inform, my lord. They have a separate, my lord, standing on.
Yes, Bora.
Yes, Bora.
Even I had informed him in the morning hours. I informed you about the listing of this matter.
Okay,
His
but Mr.
His name has not
Chaudhary,
been shown. That's why.
learned counsel for the petitioner. Why has it come out for orders today?
Because of this one, this amended cost title
Oh,
correction.
amended
laws.
Correction.
Yes. Okay, heard Mr. S.P. Chaudhary, learned counsel for the petitioner, and Mr.
A. Fukan for
A.
the
Fukan, learned
elementary.
standing counsel for elementary education department. Secondary education.
My lord, elementary.
A secondary education is also a party.
My lord, no, my lord. Only
Yeah.
elementary and finance, my lord.
Okay, P.N. Sharma appeared for secondary or it is wrongly reflected?
Wrongly reflected.
Okay. A. Focon for Learned Standing Council for Elementary Education as agreed to by the part and department, full stop. D. However, there is no representation from on behalf of respond number
8, Lordship. Director
respond number
SCRT.
8. Who is the director of SCRT Assam?
Yes.
As agreed to by the parties? No, not agreed to. Mr. S.P. Chaudhary submits that the matter may be taken up day after tomorrow.
Showing the name of Mr. S. Bora, Lordship.
Day after tomorrow will be what date?
Wednesday, Lordship.
13th of May 2026. It is also noticed that the name of the SCRT, name of the
Standing Council, Lordship.
the Standing Council of SCRT has not been reflected in the cause list. As such, registry is directed to reflect the name.
Mr. S. Bora, Lordship.
Mr. S. Bora.
Bora.
Name of Mr. S. Bora, who is the Standing Council of the SCRT in the cause list.
Right.
List this matter
On 13th, Lordship.
on 13th of May. Mr. Goswami, there were so many affidavits here.
Yes.
Readings are complete over.
Yes, I think.
But on the last occasion, you were supposed to bring some resolution by
Yes,
five. That is done.
Yes.
Oh, it is done.
Ladyship, if we may be allowed, this is done, but with some challenges like left out. There are certain issues like.
Challenges left out now, then you have to amend your writ petition.
No, not from our side. Like we would like to challenge the matter. Like as of today, I have not been informed about the DPC result, which is supposed to be done on the very day. But they have completed the DPC. I mean, it's a meeting like where evaluation.
Department of Promotion.
So that day, evaluations were done. However, the candidate was not informed whether he has cleared or not. So the DPC remains incomplete. Like if oral communication simply completes it, that is beyond our control in any way. This is one thing. Second point, if Lordship may kindly peruse point number 3 in the additional affidavit. So they have made some self-contradictory claims where it says.
Made self-contradictory claim?
Yeah, in the sense like it says I was asked to present some documents, including attendance sheets of the classes being taken from 2013 to 2017, which is the contention period.
Acha, are we hearing the matter
No,
for final
ma'am. So
disposal?
just allow us to file a affidavit in reply within 2 weeks' time.
Affidavit in reply to whose petition? Whose affidavit?
The latest one, like being received from the Learned Council.
There are so many affidavits, you still
last
want
one,
to file a reply.
5/5/2026.
Ouch. Huh? Filed on
5/5/2026.
by respond number 2.
Yes.
This is a contempt application. Acha, acha. 5th of May 2026. You want to
this
file a
matter was-
reply? Okay, heard, Mr.
H. Sharma.
H. Sharma, Learned Counsel for the petitioner, and Mr. B. Goswami, Learned Counsel for all the respondents.
I think two, yes.
For respond number 2.
One.
1 and 2. Oh, only 2 respondents?
Yes.
For the respondents? Mr. Petitioner, to the affidavit in opposition filed on, what date I said?
5/5.
On 5th of May 2026. Prayer is allowed. List this matter on 1st of June 2026.
Strictly obliged.
No more pleadings, no more affidavits, huh? You will not come up again with some AO. There are so many affidavits here. Yes. contempt case?
Not in compliance of the order, my lord, speaking order has already passed, my lord, that is on record.
Rejected?
Yes.
The way you have said that, no, it is rejected.
Maybe closed with liberty to.
Give me that. You have
Well,
filed.
it is there, my lord.
You filed affidavit.
No, no, my lord, it is, as my lord instruction is there, my lord.
On the last occasion, I think it was
Please, my lord.
supplied to the court.
That is even there, my lord.
Acha, order dated 27/4,
Yes,
26?
27 my lord,
27/4, 26.
Yes, yes. Apex side.
27, order dated 27.
Hmm.
No, relevant portion is next page, my lord, decision. Student receive the receive वाला वाला है, student
So this is for what? What order have they violated initially?
There was an order passed by this honorable court granting them 3 months' time to dispose of my representation regarding the claim.
Page 15.
Lordship.
So you were directed to file an appeal before the authority
Lordship.
for regularization, provincialization of your service.
Accordingly filed, but by way of this order.
Right. Heard, Mr.
MH Loskar.
M.H. Roskar, learned counsel for the petitioner. This is what item number?
36.
56. M.H. For the petitioner and Miss
S. Sutia.
S. Chutia, learned counsel for respondent number 1 and 2.
my lord.
By this petition, the petitioner has prayed for his has prayed for provincialization. Oh, no, this is contempt. Oh, by this contempt application, filed under Section 12 of the Contempt Act of 1971, read with Article 214-15 of the Constitution of India, and Contempts of Court Rules 1977, the petitioner herein had filed the, has raised the issue of non-compliance of the judgment and order dated 10/1/2025, passed by this court in writ petition number 413 of 2024. By the said order, this court had directed the Secretary to the Government of Assam, Department of School Education, and the State Level Scrutiny Committee to consider the appeal filed by the petitioner and pass a speaking order within a period of 3 months from the date of receipt of the representation. This instruction was placed before, then why was not, it was not disposed of?
Because on that day, my lord, petitioner took time for.
I wanted to go through.
Go through the. Full stop. Then thereafter, on 29/1, 2025. The petitioner made a representation before the Secretary to the Government of Assam, Department of School Education, reiterating his prayer for provincializing his service. When the matter is taken up today, the learned counsel for the petitioner, Ms. S. Chutia, placed an instruction, placed an order dated dated 27/4/2026, by which the director of passed a speaking order to the effect what is his name? Robin Bora. That petitioner was not recommended by DSC district. What DSC is?
District Scrutiny Committee, Mr.
District Scrutiny Committee. Dhemaji, as per clause 13(6) of the Act. 13(6) of what Act?
2017 Act, madam. Provincialization of teachers.
13(6) of provincialization of, give the full name.
I'll give you a copy if it's wrong.
Okay, I'll get it. 2017 Act, huh? Ouch. 2017 Act.
Yes, madam.
Where is that in this book?
Give them a moment. I'll make period stays 105, madam.
105?
105.
505?
105. Madam.
105. Provincialization of service of teachers and reorganization of Educational Institution Act 2017. And that the District Scrutiny Committee, Dhemaji, recommended 3 numbers of teachers against 3 subjects. And that, and also that respondent number 6. Oh no, respondent number 6 no. And that one Rajiv Kumar was recommended against the post of language teacher. Rajiv Kumar. 3 teachers against 3 subjects, right? And then, and in pursuance to the same, the services of said 3 numbers of teachers were provincialized as tutor under the said act. It is also stipulated that enrollment position of the school is not eligible for recommending any other additional tutor. As such, the claim of the petitioner for provincializing his service was rejected. In view of the same, this contempt application stands closed with the further liberty that petitioner may approach this court again in any subsequent cause of action. Okay? Petition is disposed of.
May I approach the same, challenging the said order, Your Lordship? By challenging the said order, Your Lordship.
You do whatever, it's any cause of action.
Anyone?
Oblige, Lordship. Lordship, I'm praying for some more time. Lordship, on the last occasion, I made a mention with regard to some instruction I will be getting. because the petitioner is asking for the disability pension. The thing is that she is otherwise not entitled for the disability pension because of the period of service.
Petition side is not there today.
Not there. I had informed her in the morning hours, Lordship, probably that's why, because I'll be taking time. 2 weeks time may be given, Lordship, for this, to obtain the necessary speaking order, Lordship. Because we are basically rejecting the prayer of the petitioner, Lordship.
The time frame is maintained.
No, because the petitioner, this performance of the duty was only for 4 years, Lordship, and the requirement is for 10 years. If the petitioner is entitled for the disability pension, she will have to discharge service for 10 years. But the period of service only
Only
4.5 years, Lordship. So that's why we are rejecting. So only thing is that, Lordship, I have not received the speaking order because it has to come from Delhi, Lordship, from the Home Ministry. So I'm just waiting for that
Okay,
particular.
none appears on call for the petitioner. However, Mr. S.P. Chaudhary, learned counsel for respondent number 2.
For the all the contemnants, Lordship.
For the respondents, submits that he requires some further time
Yes, Lordship.
to get the
Necessary speaking order. Speaking
speaking order passed by the concerned authority. Or you will only pass.
He will pass and I will provide this copy before this honorable.
Necessary speaking order passed by the authorities. List this matter. Prayer is allowed. List this matter on
After 4 weeks, Lordship.
on 5th of June, 2026. Yes. Yesterday or 5th, you are not there.
I'm extremely sorry.
It's okay. So what is this contempt case?
Contempt case, in the, they have received the notice. The process server report says they have, for the office note, they have received the notice. Therefore, taking care. They remain absent or not.
No, as on date, no AD card nor answer notice returned.
Process server report.
Process server report received back states that notice has been served to the respondent.
Yes. Lordship may proceed with the contempt proceeding because after receiving the notice, they had received the notice, it is clear, the office note says.
So let us await for some time. They might come and represent themselves. This was when? 27/4, not many days. Right. We will await for some more time. What do you say? Because process server report has come back saying that it was. So let the respondent know, respond. Okay. Heard, Mr. FZ Majumdar, learned counsel for the petitioner, who has placed the office note dated 27/4/2026, wherein it is stated that although no AD card or answer of notice has been received back, but a report has come from the process server that notice has been served upon the respondent. For the ends of justice, this court deems it fit to await for some more time to see whether any representation is made. Or you have to take fresh notice, fresh steps.
May not be required because they have received the notice. The process server report clearly says they have received. And after receiving notice,
But no AD card or answer.
AD card normally, that may not
Who
come,
are these contemners? Who are these respondents?
but is superintendent of police.
Oh, Amitava Sinha. He has retired, I think. Or what?
I,
Take the instruction.
Lordship, I'll take.
Take the instruction whether wait for the same, wait for some more time. Further, the petitioner to take instruction as to the present address of the respondent. List this matter on 9th of June.
Lordship.
Okay.
39 also, the office note says that the respondent received the notice.
Same party.
No. Isn't
Senapati.
Director of Secondary Education.
Here also same.
Office note same
Received by one office staff of the respondent. Right.
office staff, Lordship, generally the process server is not allowed to visit the chamber of the director. So normally the office staff, his PA or someone will receive.
So let us await for some more time.
Lordship.
Heard Mr. FZ Majumdar, learned counsel for the petitioner, who submits that the, who has placed the office note dated 27/4/2026, which, wherein it is stated that although no AD card or unserved notice is has returned, but the office service, process service report had come back stating that notice has been received by one office staff of the respondent. As such, this court deems it fit to await for some more time so that the respondent is represented. List this matter same day
Same,
on,
9th of-
when did I fix the last one?
9th.
9th.
Okay.
Item 40.
Yes, Ms. P. Borua.
Me, please, Your Lordship. Lordship, this contempt petition, Lordship, by office note dated 3/4/2026, AD card has not been returned for respondent 2 and 4. Lordship, respondent number 1 has already appeared. Respondent number 3 had already received in the month of November. After 6 months also, no one is appearing for respondent number 3. Lordship, the main answerable respondents, Lordship, for non.
1 and 3.
No, Lordship, respondent number 3.
Okay, only 3.
One has
Well,
appeared.
respondent number 1, somebody
One has
appears.
appeared, madam.
Huh.
This order, my lord.
Main is respondent number 3.
Yes, madam.
2 and 4?
2 and 4, Lordship, AD card, Lordship, not returned. We have taken fresh steps, Lordship.
3 is a private party, Anwar Hussain.
The director, Lordship.
Oh, it is not reflected here that the then director, he must have retired or something.
No, Lordship, he's still in service, Lordship, I found out.
So there is no office note with regard to respond number 3.
Lordship, 10/11/2025.
Uh-huh.
10/11/2025.
10/11/2025.
Lordship.
10/11, yes. AD card returned from R3. Acha. R3 was otherwise served.
Lordship served. And also, there is no compliance, Lordship, although it was directed to comply with the order within 2 months, Lordship.
So 3 was complete, 1 to 4 was left. 1 is complete, now 2 and 4 are not served.
Lordship.
Right. And these are the total respondents.
Lordship, 4 respondents.
5 is there.
4 respondents, Lordship.
Oh, 5, 4.
4, madam.
Oh, acha. 4. Jeherul Islam, Inspector of Schools. Number 3, Jagadish Prasad Brahma. He is the Director of Education. So let him be personally present then, or anybody from Bodoland Territorial Council.
Yes, Lordship.
Pokrajhar. What about respond number 2?
2 and 4, Lordship, AD card awaited. We took fresh steps also.
2 is also Bodoland.
Lordship.
4 is also Baksa, IS, Inspector of Schools. So what to do then with regard to respond number 3? 2 and 4, can you take fresh steps?
Lordship, I'll take fresh steps, Lordship.
2 and 4.
2 and 4, Lordship.
3 is complete. What to do with 3? Shall I direct for his personal appearance?
Lordship, because there is no compliance, Lordship. It's been almost a year since the passing of the order, my lord.
In November he was served, right?
Lordship.
Or I can do one thing, I mean it can be done through the office of the respondent number 3 Gauhati. I mean, can it be done through the office?
Because it's a contempt, my lord.
Contempt, Lordship.
No, service through the office. Service upon respondent number 3, but through the office of the Director of Education.
Both the director are different, my lord. BTC is all together, my lord, they are autonomous body, my
Or
lord.
through the government advocate, BTC.
BTC standing council is there, my lord. I can inform her, my lord.
It can be done through the BTC standing council.
My lord, my lord. That can be done.
And if that could not be done or nobody appears, then we can call for his.
My lord.
Lordship, I'll.
Okay. You serve a copy through the BTC.
Lordship, for all the three respondents are 2 and 4, Lordship. With the
Others, let us await.
Lordship.
3
For
because it
3,
is served.
My lord.
Heard Miss P. Borua, learned counsel for the petitioner, and Miss S. Chutia, learned counsel for respondent number 1. It is seen from the office note that service of notice upon respondent number 3 is complete way back on 10th of November 2025. But till date, there is no representation on his behalf. As such, for the ends of justice, it is directed that the petitioner may take steps for service of notice upon respondent number 3. Fresh steps for service of fresh steps, notice through the through the Standing Council of Borolan Territorial Council. You give her a copy, then she will do the needful.
Lordship.
As far as respondent number 2 and 4 are concerned, it is reflected in the office note that neither AD card nor answer notice had been received. And the office note is dated 30th of April 2026. As such, this court deems it fit to await for some more time as far as service of notice upon 2 and 4 are concerned. Nalage to diswani ke upar nalage. Await for the service of notice. List this matter, the petitioner is directed to take fresh steps as stated above. List this matter on when?
Lordship,
You give her
last
the
week
cop-
of May, Lordship,
Uh-huh.
with 28 May, Lordship.
Okay, list this matter on 28 will be too short. 1st of June.
Lordship.
Okay.
Deeply obeyed.
If nothing happens, then we will call for it.
Deeply obeyed.
Lordship, in this case, I have to beg your Lordship pardon because this case has been looked after by another APP Lordship, AK Parakar Lordship. Due to some urgency, he has to go Lordship. So I have not looked into that. I am in different court Lordship.
Acha.
So kindly fix it tomorrow Lordship.
So, okay, tomorrow,
Lordship.
right? There are, what, TCR?
TCR is there Lordship.
Okay. So, heard Mr. H.R. Chaudhary, learned counsel for petitioner, and Mr.
KK Das. Lordship.
KK Das, KK Das,
KK Das.
learned counsel, additional public prosecutor appearing for the state. Mr. Das, APP, submits that the concerned APP who has looked into the case has to leave the court for some urgency, and as such has prayed that the matter may be taken up tomorrow. That is on 12th of May.
Lordship.
Prayer is allowed. List the matter accordingly.
Okay.
And what about the other matter, AB?
Maybe there is a CD is not available Lordship. CD not available.
Case diary is required. AB.
Yes.
Oh, call for the case diary. That was in April 26.
Already called my.
You bring it positively on the next date.
It is here in Gongia, ma'am. After tomorrow, possible.
Difficult home away from.
Day after tomorrow, little difficult. 18th of May,
Lordship.
Monday, next
Lordship.
Monday.
Lordship.
Heard Mr. H.R. Chaudhary, learned senior counsel, assisted by Ayu Chaudhary, learned counsel for the petitioner, and Mr. K.K. Das, learned APP for the state. Mr. Das submits that the case diary has not been received and has prayed for some time. Prayer is allowed. List this matter on 11th of May.
That ensure my brother.
18 Lordship, 18 of me.
Oh, yes, 18th of May, on which date the learned APP should produce the case diary without fail.
Lordship. Much of-
Yes.
Respondent was directed like last occasion to get their instruction.
Lordship, in this matter, I have received my instructions, my lord. My lord, here, my lord, the department has sought for some time, my lord, for compliance, my lord. So therefore, I need 2 weeks more time, my lord. It is in
Otherwise, the
process.
time period given in the writ proceeding is over.
No, my lord, it's a contempt matter. So, my lord, to comply with, my lord, since now the elections are going on, this particular thing was supposed to be placed before the higher power committee. So accordingly, the preparations for the, my lord, In this connection, it is further stated that the relevant documents pertaining to the appointment and qualification of the petitioner was verified and the report on the findings of the verification is under preparation for placing before the next high power committee meeting. So what has happened is because of the elections, the next high power committee meeting could not take place.
What is this matter? What order you have violated?
My
What?
lord, it is for selection, appointment, no? Appointment.
For appointment?
Therefore, my lord, some time may be given, my lord. In the meantime, 2 weeks, my lord, then perhaps, my lord, next committee, we can place it, my lord.
Acha, so there are so many committees. One has recommended what? One has placed on to the other.
Yes, my lord. There's a committee which we have to place this, my lord, after the, my lord, scrutiny of the director, my lord. The director will place it before the directorate will place it before the high power committee. Because of the current situation, my lord, we need some time, my lord. But 3 weeks will be better, my lord. 3 weeks will be better because of the fact that.
You are Mr.
A high.
Huh?
A high.
A high. Learned counsel heard Mr. A high, learned counsel for the petitioner, and Mr. A Fukon, learned
for the sole respondent.
For
the sole respondent.
Learned counsel for this one respondent only.
My lord, it's direct.
Learned counsel for the respondent. Mr. Fukon submits that the order has been complied with. The respondent is in the process, has started the process for complying with the order dated
6/5/24.
6/5/2024, and that due to some not preoccupation due, and she needs some further time to pass the speaking order. The prayer as such made by Mr. A. Fukon is allowed. List this matter again on
After 3 weeks, man.
8th of June.
8th of
By that time, you please
I'll place it.
pass the
Deeply.
speaking order. Right?
May I be, in this matter, service is awaited, Lordship, on time matter, Lord. We have taken fresh steps also.
Fresh steps you have taken.
Lordship taken.
Earlier also you had taken, it could not be served. Now again, fresh
Yes.
steps. Now also till date, no ID card.
Nothing.
Who is this respondent?
Director of Elementary Education, Lordship.
Hmm? Wait. Director of Elementary Education. Same respondent like in the earlier case. Suranjana Senapati.
Director elementary education kahile bana. Eto bhul hoise.
Pin number is wrong.
PIN number is wrong.
Yes, ma'am.
Oh.
19 number. Eto very high.
Yes.
You correct the PIN number and take fresh steps.
Ma'am.
Okay. Heard, Mr.
Pin number 19.
MK Hussain. You are MK Hussain, right?
Lost.
Learned counsel for the petitioner. Who places, who submits that service of notice upon the sole respondent could not be effected, and that he had taken fresh steps as ordered by this court, but it is seen in the office note that no AD card or unserved notice has been received back. However, the learned counsel for the petitioner submits that there is some error in the PIN number in the address mentioned with regard to the respondent.
Correct, my lord.
PIN number is also correct. This is a very simple address. What do you need? Only if the PIN number is different, okay.
19, ma'am.
You do one thing, you take it through the Standing Council of Elementary Education, right? Or did you have to mistake it? Since so many efforts were made by the petitioner to serve, to cause the notice, to serve the notice upon the said respondent, but was of no avail. It is directed that the petitioner would take fresh steps through the Standing Council of the Elementary Education Department. Full stop. List this matter again on 25th of May, 2026. Right? You take the fresh steps. So many contempt application.
Yeah, please.
43?
Steps on November, 3rd November 2020.
Again, service not complete.
Complete matter. I may be allowed to take fresh steps.
Fresh steps. Who is this respondent? Sole respondent.
Sole respondents.
Narayan Kumar, Department of School Education. Yes, Ms. Chutia. Secretary to the Government of Assam, Department of School Education. Why this service is not complete? Gauhati 6. PIN number is different or what? No, no?
What is 6? Steps, third.
So take it through the Standing Council of
Yes, ma'am.
Department of School Education. There are separate sets. You can do it. Okay, take it through the Standing Council, right?
Yes, madam.
Heard Mr.
H.L. Ashkar.
H.L. Oscar, Learned Counsel for the petitioners. It is seen from the office note that steps for service of notice upon the sole respondent was taken in the month of November 2025. But till date, the services, the notice was not served, is not served. As such, it is directed that the petitioner should take steps for service of notice upon the sole respondent through the Standing Council of the Department of School Education. List this matter on 28th of May. 28th of May. Gauhati University.
My lord, this in item number 44, my lord. In this case, my lord,
44, what happened?
yeah, my lord, this PD9 is required to argue this case, my lord. He is unavailable, my lord. May I pray, my this matter be taken about 3rd of June, my lord.
Why his inability? He
lord.
became a senior and then he became inable or
No,
what?
my lord, actually he has got some personal problem, my lord.
Acha.
So he cannot come, my lord.
Okay.
Wife is unwell.
So, Mr.
Fukon,
what do you say?
My lord, I'll have
He
to
is the
agree.
respond number
I'm for the opposite party number 4, my lord.
4.
In the IA, my lord.
This is contempt. I is
No, no,
4.
IA in the review they have filed, my lord.
It's a
This is not contempt.
Not more contempt.
Oh, acha, acha. This is
Contempt
review
tagged, my
application.
lord.
Acha.
contempt petitions were tagged.
Contempt petitions were tagged, my lord.
Was tagged.
Yes.
But this is review.
IA in review, my lord.
I in review.
I in review. For what purpose?
Mirror for some clarification, my lord.
Some clarifications.
Yes.
Okay. You are for respond number?
I'm for the opposite party, respond number 4, my lord. In the IA, my lord.
The private respondent.
Sri Midula Sharma.
Yes, madam. I'm the read.
What about 1, 2, 3?
1, 2, 3.
State government.
These are higher education,
Yes.
finance,
Yes, yes.
higher education, finance and all those.
Yeah.
1 and 3, you are there.
Two.
1 is higher education, 3 is higher education. 2 is finance.
And five.
Finance,
is
Mr. Nayak appears, I think. Chaliha.
Yes.
And 4, you are there.
Yes, madam.
5 is also secondary education.
Secondary education.
Secondary education, I think D. Mushahare.
Yes. She may.
Anyways, BD Nair is for?
For
4.
respond number 4, madam.
Has he filed affidavit?
Yes, madam. Everything filed.
Everything is filed.
Everything is complete.
Okay, in the IA, you write. Heard Mr. PJ Fukon, Learned Counsel for the applicant. And Mr.
G. Alam.
No, I is by Gauhati University.
Gauhati University.
Okay. PJ Fukan for the applicant and Mr. Your name?
G. Alam, madam.
G. Alam, Learned Counsel, appearing, Learned Counsel, you are there on
Yes,
record?
yes, madam.
For the respondent.
Respondent number four.
Number 4. Mr. Alam submits that Mr. P.D. Nair will argue the case and is indisposed today and has prayed for some time. Prayer is allowed. Mr. As Mia, Learned Counsel, appears for respondent number 1 and 3. Pleading, it is also submitted that pleadings are complete. Even in review, pleadings are complete.
Yes, yes.
We
No,
can take up
review,
that-
madam, review has been disposed of.
Oh,
It is
review is
IA, madam.
disposed. Acha.
IA, madam.
Some clarification.
Some clarification, madam.
Okay. Prayer is allowed. Bless this matter when?
3rd, madam, 3rd of June, my lord.
On 3rd of June,
Madam.
right?
Obliged, madam.
2026.
Most of them.
Yes. 46. This is what? Writ. What is this I for?
There is an IA for recalling of an order wherein I have been implemented as a party respondent. Your Lordship,
You said on the other day.
yes, Your Lordship, the petitioner has filed this writ petition. He has certain grievances against the Forest Department. He entered into a contract. The contract was there for 2 years. Thereafter, it was extended, and thereafter it was cancelled for some reasons or others. Now, we are French development agencies. We are involved in financing various projects like the IMF and the ADB, Asian Development Bank, and all those. So I am situated at France. So I have sponsored the Forest Department in the state of Assam for certain projects on biodiversities. Now they were undertaking those projects. While the projects was there, in terms of that project, the petitioner was engaged for certain works. And there is a dispute between the petitioner as well as the Forest Department.
Mm.
So in the writ petition, there is no whisper against me in the entire writ petition as to what, and he has no claim against me also. Now, thereafter, he filed a impleadment application. If I may just hand over the impleadment application to your Lordship.
That was allowed.
Yes, that was allowed without hearing me.
Hmm.
And there was no statement against me.
Hmm. Now you have come for vacating. What?
No, I've came for striking of my name.
Hmm.
Because we are not supposed to get engaged in the court cases. Now, I'm neither a necessary party nor a proper party, nor I am in any way involved. I'll just read the para, your Lordship.
You have filed your objection to this IA. What?
No, this is an impediment application which he has filed.
And
by virtue of this
where is
impediment
the order?
the order is in my recall petition, your Lordship. I'll just read the para by which is that the agency franchisee development, French development.
Which paragraph?
Para 2, page 4.
Hmm.
Has your Lordship got it? That the agency franchisee development, French development agency has partnered with the state of Assam and Assam Forest Department for the purpose of sustainability, forest management and biodiversity conservation in Assam. The agency franchisee development, French development agency provided fund for the Assam project on forest and biodiversity, phase 2, which is a necessary party in the writ proceedings. At the time of filing of this writ petition, the applicant inadvertently did not make such and such as party respondent number 4, for which it is required to be implemented. Now, what is the reason? You don't make any allegation against me. There is no relationship between you and me. I have not appointed you as the agency. So why you have arrayed me as a party respondent? Now your Lordship will
Now
kindly...
that you have partnered with state of Assam
Yes.
and you provide funds.
Yes, your
For
Lordship.
various projects.
Right, your Lordship.
On biodiversity. And so you were considered to be a party, but why? What is the matter about?
Matter about my lord petitioner was termination from his service. In this regard, I would like to
Petitioner terminated from his service?
Yes.
Or he just said contract work with... you had to-
Contract work, initially he was appointed for 2 years. Thereafter, he continues in this project, my lord. He was appointed regarding this. Regarding this, I would like to submit my written submission, my lord. I have made this.
With respect to the IA?
Yes, respect to the I have filed also my objection in this.
For deleting? You
Yes.
had filed your objection?
Yes, already filed. And today I would like to file my written submission. somebody may.
Today, why has it come up for orders?
For recalling of the order,
They
Your
file
Lordship,
this IA
for
to deletion their name as
Mm.
party respondent.
Mm.
And this honorable court by the order dated কোনোবা লগ না? 18 December 2024
Mm.
pleaded
Mm.
the respondent number 4 that they are the necessary party for adjudication of the party.
Mm.
And I have details I have submitted this written submission.
So according to them, he is not the necessary party.
They are the proper party, my lord. This
According to him, he is not a proper party, no necessary party, nothing. They should be struck.
From my perspective, he is the proper party, my lord. Why he is a proper party? Because respondent number 4 is not mere a third party stranger to the proceeding. They are the principal funding agency of the Assam Project on Forest and Biodiversity Conservation.
Maybe they are the funding agency, but you
For-
cannot claim any relief from them.
For my lord,
Can you claim any relief from them?
no,
Then,
I don't want any relief against
then
them.
why will you make him a party?
Only for proper adjudication of the matter. I have been pleaded.
Anything
there-
proper adjudication, that's a very vague concept.
My lord,
Where is the order allowing the impleadment?
Your Lordship, that is in my recall petition. If Your Lordship kindly take up the IA 2871,
Huh.
page 20.
Page
in the
23.
appointment letter, my lord, the
18/12/24 order.
Yes, Your Lordship.
yes.
This is 24 order.
Yes, Your Lordship. By this order, I was impleaded.
And now you have come up for, when did you file the IA?
I have filed the IA long back, Your Lordship.
Acha.
Thereafter, I have filed my objection. Again, they have filed their regender affidavit.
Hmm?
This is something I filed in way back in June 25. The
Hmm.
first IA I filed before that. Thereafter, again, I filed this IA. Because this has to come from France, Your Lordship. They have to sign it, get it verified from the consulate, and then I receive it here, Your Lordship. Your Lordship, there is no claim against me.
Hmm.
It is only to create a blot, Your Lordship. Just imagine a person who is funding for the various socio-economic projects in the state of Assam. That party has been dragged here for no fault of theirs. I am very candidly and very fairly submitting. He may have some claim against the forest department. That is up to the forest department to clarify. I am not on that.
The funding agency, why, Mr. Counsel? Not
My lord,
required.
As per order 1 rule 10, I have implemented because the appointment letter.
So tell me the fact, background of the case. What appointing? What happened?
Background, the main petition has been filed by the petitioner claiming service and remuneration related.
Acha, wait. Writ petition was writ petition number 3573.
Yes,
This is filed by whom?
filed by the petitioner, that is me.
3573, that is you?
Yes,
So 3573 was filed for what purpose?
for service and remuneration relief in the Assam project on and biodiversity conservation.
Let me see the writ. Someone recommendation.
Petitioner was relieved from service on 1/6/2024. He was engaged in this
It
project.
was a contractual appointment.
Acha, wait. What appointment? I'll just see. So you continued in service for 2 years, right?
Yes, there was an agreement, yes.
And then
Thereafter,
after the expiry also, you continue to receive the
Yes.
remunerations.
Yes. I was continued my service.
And then a notice inviting bid was issued for procurement of vehicles.
Yes,
One of the two bidders, the successful bidder, SBL. This is somebody different, right? SBL Knowledge Service
Yes, Your
yes,
Lordship.
this is another.
supplied the vehicles and accordingly 50% of value of vehicles was released and 50% was not paid. Submission of forced documents, clarification regarding bid was sought for by the principal conservator of police from the petitioner. Why the clarification was sought for from the petitioner that some fake documents was given? Submitted his reply. The petitioner came to know that FIR was lodged in This is you and the petitioner and the forest department.
Yes.
You were the senior procurement specialist. You were appointed for 2 years. I think during your tenure, some bid process was initiated.
Yes.
And 50%, and this a successful bidder has no connection with you.
I
Right.
had the connection because in my appointment letter,
Because you were the
in my appointment letter
Hmm.
of the petition specifically bears the name and logo of the funding agency, establishing a direct link between the execution of the project and the agents. And in the present case, though no relief sought for against the respondent number 4, but the continuance of the service for the post of senior procurement depends on the funding of the project APFBCS by the respondent number 4. Therefore, respondent number 4 is a necessary and proper party in the connected writ proceeding because the continuance of the project depends on the funding on the project by the respondent number 4. The agreement is signed by the project director of the project. The appointment letter dated 9/6/2020 itself contains.
Where are you reading from? Reading
In
one
my
line?
objection, affidavit in reply.
You don't have to read. Tell me that. See,
My
you
lord,
must
the-
be the funding agency.
Yes.
But what connection you have with the petitioner?
They are the
Petitioner was appointed as a procurement some specialist, and he was terminated. His services was done away with because of some FIR lodged
yes.
against 8%, including the petitioner. So his services were done away with. Somebody else was appointed in his place.
Yes.
Right. So it is between you and the forest these officials.
But
These French people, they fund for some regions, eco diversity or whatever. So what? Why are they? They are not required to be party respondent.
because
In my first impression,
in my read petition, if your lordship may see the
I have just gone through your
document,
synopsis.
page
I have
number,
not.
page number 19.
Hmm.
Not 19. Page number 18.
Hmm.
FD and their logo is there, and based on their funding,
To Abdul Wahid Chaudhary, who is he petitioner?
petitioner.
He was appointed as procurement.
Yes, only for this project run by based on the
Senior
funding of-
procurement specialist in Assam Forest Project on Forest and Biodiversity Conservation. Right. Project director.
respond number 4 is not a mere third party, my lord. They are the principal funding agents. And their logo is there.
We can do one thing. We can take up
And
the
I have
petition and
citations in this regard. my lord.
dispose of the matter instead of going into this IA.
No, your lordship may dispose of the matter, but prior to that, your lordship, in that case, our name comes here, that we are a proper party or a necessary party. I am here on one count, that I am neither a necessary party.
See, in order to see proper party necessary, I have to go through the entire writ.
Your lordship, I'm very fairly submitting once again. He might have a case or he might not have a case against the forest department. And the forest department will make a submission to that effect, that whether I am a necessary party or why to drag a foreign national when they are funding the projects? This is a blot to the nation, nothing more. And he is doing it knowingly. Your lordship, the purpose is otherwise. The purpose is to make the whole water dirt. As he cannot fish, he will not allow anybody else to fish in this water. Your Lordship, let him show, justify why I have been arrayed as a party respondent. There is a judgment of the Delhi High Court Division Bench, which directly says that no, the person who funds the project cannot be arrayed as a party respondent. I have placed the judgment on the earlier occasions, Your Lordship. This on the record, Your Lordship. If Your Lordship kindly looks at it.
The judgment is totally different from my case, my lord. I will show.
Your Lordship, let him make his submission. I'll make thereafter because he's trying to disturb the decorum also. He's jumping in the middle. That is not acceptable. So let him make his submission. Thereafter, I'll make my submission.
No, why I am suggesting you is because I have to go through the entire thing in order to see the involvement of the French company in this instant matter.
Your Lordship, but that.
I'll take up the entire rate.
No, Your Lordship. I would like to say, Your Lordship may allow the petition, dismiss the petition. But here is a case where I'm praying for a recalling of that order or deletion of my name. Because I am no way involved. Why should I be dragged into the litigation, Your Lordship? His entire case is that he has a case. He might have committed some fraud. He might not have committed some fraud.
And this French company, they are the financer of Assam project, only this project.
There are various projects, I suppose.
There are various projects.
Various projects from time to time they finance. It is on the biodiversity and because of the environment and other related projects. Now, all of a sudden, during the pendency of the writ petition, there is no statement against me. He comes up with the IA. And I've just placed the IA. In that IA, he has not stated anything, what grievance he has against me. He has only stated that as I have sponsored, so therefore I should be arrayed as a party respondent. Now, can that be a justification to that extent? Why a person should be arrayed as a party respondent?
Acha, you were not heard when the IA was taken up?
No.
Why? Notice was not.
No,
okay,
notice was not
completing
issued. It was
application.
allowed on the same day itself without hearing me, Your Lordship. And Your Lordship knows very well when in a recall petition, if the party is not heard, then that goes. And moreover, I can place the judgment, a person who has funded the project, he has no bearing with the case. He cannot be arrayed as a party respondent, Your Lordship.
You have some judgments to
Yes, Your
cite.
Lordship. Yes, Your Lordship.
I've seen here few judgments are being tagged.
Union of India versus Rampal.
No.
Assuming true.
Maybe in the IA it's there.
2010 SCC Online, Delhi 2906.
Hmm.
Has Your Lordship got it?
Mumbai International Airport and what?
Union of India
Versus Rampal Singh.
Yes, Your Lordship.
It's here.
Yes, sir. In this case, Your Lordship, I'd like to rely on this judgment. This is a case which was funded by the central government. Central government launched a scheme, ICDS, for lactating mothers, pregnant women, and for the school children to avoid the dropout. Now, what happened is that, so various agencies were allowed to look after these projects. Now, AIMS Delhi, New Delhi, was appointed as the nodal agencies. Now, what happened? When AIMS Delhi was in charge of this project, they appointed some persons. And accordingly, the project was continuing. Now, thereafter, the director of the AIMS, he retired. And then the project was discontinued. So, all those private respondents in this case, respondent number 1 to 6, they were given an option, either you come with us or you be there, but your your status will be that of a contractual appointment. Now, they filed a writ petition before the court, making AIMS as a party respondents. Sorry, central government as a party respondents. The court said that no, central government was only funding the project. You are not appointed by them. Here is a case, we have funded the project. We have not appointed him. And therefore, we are not neither a proper party nor a necessary party to be arrayed as a party respondent.
In the first blush, court satisfaction is that they are not a necessary party because they are just simply funding
Yes.
the forest for biodiversity conservation and all that. But
My lord.
if he has something more to say,
The judgment relied by the senior.
May I
counsel.
just read para 34? You take your seat, I'm not completed. Para 34.
Page paragraph 34, yes.
The upshoot of the entire discussion is that, has your lordship got it?
Yes.
The upshoot of the entire discussion is that respondent number 1 to 6 are not the employees of Union of India. The tribunal misdirected itself in directing the Union of India to consider the reinstatement of respondent number 1 to 6 in any of the projects relating to the ICDS being run by the government. Now, if your lordships kindly come to para 23.
23.
Yes, your lordship.
Page from the aforesaid facts.
Yes, your lordship. From the aforesaid facts, it is crystal clear that no master-servant relationship existed between the Union of India and the respondent number 1 to 6, and thus the said respondents cannot be considered as the employees of the Union of India. As a necessary corollary thereof, it is apparent that the tribunal totally misdirected itself in directing the Union of India to consider reinstatement number 1 to 6 in any ICDS project. It may be noted that the Union of India is simply a funding agency, and the ICDS scheme is being implemented at the ground level by the various NGOs who have the freedom to employ person, and in the said employment, the Union of India has no say. Thus, under no circumstances could any direction be issued against the Union of India. Your lordship, we have funded them. They have appointed. There is an agreement between the petitioner and the forest department. We are not a party to that agreement.
Project was initiated by you only.
No, project was initiated by
The
them.
forest.
So it was on biodiversity. Now it is up to them what they do. Now they have initiated a project. They have choose to appoint him as their PMU. There was a dispute between them. There was an agreement between them where we are not a party. Neither our consent was taken to appoint them. Neither we are there to give our consent. First of all. Secondly, there is no master-servant relationship between me and him. There is no liability I have upon him or he has upon me. If the project fails for some reasons or other, that is their problem. So why should I be arrayed as a party responsible? It is that simple, your lordship. Now, your lordship has said that the entire matter can be taken. In that case, our name will be there as a one of the party respondent in litigation, which will be a blot. Which will be a blot, your lordship.
Okay, what is the difference between, okay,
Yeah.
I've heard you.
Yeah.
So, why you say that the judgment is different, distinguishable?
In that case, my lord, reinstatement was sought against the Union of India. But in the instant case, no relief of reinstatement is paid against respondent number 4. The respondent number 4 has been impleaded for proper adjudication of the matter. That was not case a impleadment. Honorable Apex Court did not held that.
They're reading from somewhere or what?
Yes. that
You're
is my-
reading from you.
That, yes.
Where is it?
That is not recorded. That is my submission, my lord. That is not a case of impleadment. Honorable Apex Court did not held that Union of India was not a necessary party. Respondent number 4 relies on the principle that there is no direct master's servant.
What are you saying? You're saying on this case or that Supreme Court case?
Which case they have relied. That is my counter. Respondent number 4 relies on the principle that there is no direct master-servant relationship between them and the petitioner, and cites the Delhi High Court judgment to seek deletion from the area of the parties. The fact in that case, my lord, Rampal Singh case, are completely distinguishable from the present case. In that case, the scheme was run directly by the Autonomous Institute, that is AIMS, and the central government had no role in the funding and the governance structure at the operational level.
So here also they don't have any participation in the continuation of the project and all that. But
My lord,
why do you
if
want?
they argue that
No,
direct-
why are you bent upon making them a party? You seek relief from the forest department.
Forest department, but because they have financed the forest department this
So
project.
what is your
I was
concern with that?
for that, my lord, only for proper adjudication of the matter I was, because their presence is
Proper adjudication court will do by
because their-
hearing the parties.
because their presence is essential to complete settle all questions arising from the project.
What questions? Tell me the question. This is an omnibus
In
statement you are
future,
making.
if they appear and there is some question arise for that,
What question? Tell me an example that this question he will be involved.
if I will reinstate from
They
service.
will reinstate you.
No, response
Then?
number 3.
Then
My lord, I have some Supreme Court judgment.
First of all, go and go to Supreme Court judgment. First, satisfy with the instant facts. Who will reinstate you? If your termination is bad, who will reinstate you? Court will direct whom to reinstate you? The Forest Department.
Forest Department.
And why will that French company come who funds? They have got nothing to do. And why do you want that? You're not seeking any relief against the French company. Then what proper adjudication? Then you make everybody from God to the servant, everyone a party for proper adjudication. Not required.
Because the petitioner was appointed for that project, APFBC.
For the project is started by the Forest Department.
Yes.
Funding is done. Funding, whoever does it, even private person, unknown person funds certain projects. Then you'll bring those unknown person. By what name? You are not, you place your prayer, place your grievance. We will consider.
Grievance I have implemented only for proper adjudication of the matter. Because
Without
they
any
have,
reason.
because they have
You couldn't tell me a question, what proper adjudication, what will they answer? What is required to be answered by them?
because their logo is there in the appointment letter.
Logo is there,
They
there
have
must be some advertisement, but they have
This
nothing
project,
to
they
do
have
with.
finance. They have finance providing fund for which.
Same thing you are repeating. Okay, heard Mr. R. Singha.
And I have some citations whereby Supreme Court.
Tomorrow, High Court passes an order. He challenges the High Court order before the Supreme Court. He'll make High Court also a party. It is only the
These guidelines
statistic
made by
method.
the Honorable Supreme Court, my lord. One in the lower court does not make party, for which I have some judgment whereby a proper party is required. As per Order 1, Rule 10, sub Rule 2, my lord. If my lord may peruse this judgment, it will be very clear. Dada. In Ramesh Hirachand Kundanmal versus Municipal Corporation.
What paragraph?
Paragraph 6 and 14, my lord. Paragraph 6 lays down the fundamental distinction between a necessary party and a proper party.
Okay, I'll read it. I'll read it. Your question, your judgment is itself against you. See, what is necessary party? Against whom no order can be done effectively.
Yes.
Right? You are saying you are not necessary.
No.
Right. Then what is proper party? Proper party in whose presence an order can be passed, but final decision involved in the proceeding cannot be taken. Here your final decision can also be taken without you.
The court is empowered.
See what is necessary and what is proper. This goes against you. Neither you are required to deliver a effective order, nor you are required to make a final decision.
Yeah.
See, a proper party is one in whose absence an effective order can be made, but whose presence is necessary for a complete and final decision. Without you, a complete and final decision can be given. Or you are saying that without you, complete decision cannot be given. Can you say, do you say this? Then you are neither a proper party nor a necessary party. Your judgment itself is in his favor. Then you are relying on 16.
14.
14.
Which explain the scope and objectives of Order 1 to 10.
This is against you. Then what? Mumbai International.
Yes, para 8.
Mumbai International, I have also placed an objection.
Paragraph 8.
Para 8.
Not required to be a party. I'll dispose of this petition. Okay, heard Mr. K. R. Singha, learned counsel for the applicant. And Mr. He's the applicant here.
Yes,
Huh. And your name, please?
A.K. Hannan, my lord.
A.K. Hangal.
Hannan.
Hannan, learned counsel for the petitioner, that is here, the respondent.
Opposite party number 1.
Opposite party number 1. And you are for the forest.
Forest Department.
2, 3 and 4. He's
And
opposite.
Mr. Bhattakur for 2, 3 and 4.
My lord, we are in support of the application. Why, my lord? Because we should have, there has been latches on our part, no doubt, my lord. We should have opposed it on the very admission stage itself. my lord.
Since then, this
Yes, sir.
application.
But my lord, we also want this IA to be allowed, my lord, because this agency, it performs a critical role in funds. But my lord, it is not compelled to do so, my lord. It only purely out of biodiversity purposes, it funds national parks across the globe, my lord. So if we drag the agency in this litigation, my lord, we might not lose their support. So, my lord, it is in public interest that this IA is allowed, because if I may take your lordship to the agreement at page 19 of the petition, my lord.
Of the it is IA.
Writ petition, my lord.
Hmm. 19.
19, my lord.
Hmm.
Contract agreement, my lord will see. At the very top, my lord, heading Assam Project on Forest and Biodiversity Conservation Society Consulting Services Contract Agreement for hiring of senior procurement specialists for PMU of the French Development Agency funded Assam project on forest and biodiversity conservation. So it is my Assam project.
What's PMU?
Project management unit.
Yes, my lord, project management unit.
Achha.
So it is our project funded by them definitely, but they have no role in the operations of the project. We decide who we want to engage, terminate, where to spend the fund. Their fund only, my lord, comes in lump sum basis. And besides this part, my lord, in the entire agreement, my lord will not find the name of the French agency. And signatories only 2 parties, my lord. The Assam project on forest and biodiversity conservation society, that is, my lord, I am representing, because that is formed by office bearers of the forest department. And on the left side, the petitioner is there, my lord.
Hmm.
So no other role played by the French agency. So, my lord, it is from our forest department side also, my lord, it is a humble player that the IA should be allowed, my lord. They should not be, my lord, made a party.
Anyway, writ petition is not before me now.
Yes.
I will consider.
Yes.
Okay, heard Mr. So-and-so out of Bhattakurila. By this application, filed by the applicant has prayed for recalling of the order dated 18 December 2024, passed in writ petition number 3573 of 2024. What is this other order 18th of, same, December 24, by which the, where is the impleading order?
It is at page 20.
By which the LET, oh no, agency, right?
Agency.
By which the agency, AGENCE, হেৰি নহয় এজেন্সি মানে AGNCE সেইটো লিখা আছে এজেন্সি ফ্ৰেঞ্চাইজি ডি ডেভেলপমেণ্ট AFD French Development Agency was made a party respondent by impleading the same by the said order. Date this, no? 18/12/24. So and so. The learned counsel for the applicant submits that the petitioner in the connected writ petition was appointed where do I get those facts? In writ petition or in the IA itself? Was appointed as a key procurement officer.
PMU.
I'll get it in the writ petition.
Yes, Your Lordship.
Page. The petitioner was appointed as senior procurement specialist in the Assam project on forest and biodiversity conservation within bracket APFBC phase 2. Wide order dated 9/6/2020. By the said order, it is reflected that an offer was made to the petitioner to be appointed in the said capacity, and an acceptance was called for within a period of 3 days. In pursuance to the same, the petitioner was in fact appointed as the said officer, as the senior procurement specialist. In pursuance thereof, a contract agreement was entered into between the project director, project management unit Assam, and the petitioner. On 21st July 2020. With various conditions of service, right? Service. Various conditions of service are provided here, right?
In the agreement, ma'am.
In the agreement, providing various conditions of service. It is stated by the petitioner in the writ petition. Where is the impugned order, Mr. Ri, that he was terminated?
Page 47, Your Lordship.
Oh.
1/6/2024.
Wait. Where is the FIR and all that we got?
FIR 44 page.
FIR copy I don't want. I want that allegations against him.
At page 44, Your Lordship.
Now, during the course of his employment, some allegations were made against the petitioner and an FIR was lodged. And by the order dated 1/6/2024, the project director of APFBC phase 2 passed an order this is not an order, this is just a letter to the petitioner, right? Relieving him from service.
His contract was simply not renewed, my lord, if my lord sees.
His contract was for 2 years.
2 years.
But to 2024, what happened?
There is a renewal, deliberately, my lord, it is not annexed in the writ petition. That is also for 2 years. After that, it was not renewed.
Acha. Titala, before that you write, The appointment of the learned counsel for the applicant states that the appointment of the petitioner was initially for a period of 2 years, as could be seen in the appointment order. And thereafter, his services was extended by another 2 years. And that his appointment was purely contractual in nature. তাৰপিছত এইটো আহিব কি কৈছিলো সেইটো wide নালাগে starting পৰা the director has passed BC phase 2 had communicated নালাগে passed on had communicated to the petitioner that his services is no longer required in the said project, and he was directed to hand over all the files and hard as well as soft copies of all records. And it was also communicated that in case his service is required, he should make himself available to the said society. The writ petition was filed challenging the said order of relieving him from service. By making the concerned official of the Forest Department as party respondent. Thereafter, the petitioner had filed an application for impleading the applicant as party respondent number 4, which was allowed by order dated 18/12/24 as stated above. The learned counsel for the applicant submits that the applicant is neither a necessary party nor a proper party in the adjudication of the instant case, inasmuch as the applicant is simply the funding agency to the project full stop. He further stated that the applicant has not only funded the instant project, but is also involved in funding in many other projects all over the country. The applicant in the instant case has funded the project for what? For some conservation purpose, right?
Yes.
For
Conservation purpose. Mostly
for-
it goes to Kaziranga.
huh?
Mostly the fund goes to Kaziranga.
Achha. For conservation of wildlife purpose. And as such, they are not required to be made a party in the instant proceeding. The learned counsel for the petitioner, oh no, I got it here, to substantiate his argument, he relied on a judgment delivered by the Supreme Court in Union of India versus, where did I keep it? Oh, Delhi High Court.
Division bench of
Bro, where did I keep it? What is the name?
Union of India versus Rampal Singh and others.
Union of India. Oh, Supreme Court, no, huh? Delivered by the, in Union of India versus Rampal Singh and others, comma, a judgment delivered by the High Court of Delhi, by the Honorable High Court of Delhi, which paragraph wherein it is stated that, wherein it was held that a funding agency, in which case the Union of India was the funding agency, is not required to be impleaded as a party respondent, since no relief is sought for against the same. In the said case, impleading Union of India as a party respondent was considered to be incorrect, since no direction can be issued against the same. The said impleadment was struck off, right?
Yes.
Impleadment was struck off.
Right.
On the other hand, the learned counsel for the respondent, that is the petitioner, submitted that the project under which the petitioner was appointed as the procurement officer, what? Senior procurement specialist, was funded by the applicant, and that in the agreement entered into between the petitioner and the forest department, in the agreement, it was stated in the very first line of the agreement itself that the project was funded by the applicant. He placed reliance on 3 judgments passed by the Honorable Supreme Court. It interdidiba, huh? It interdidiba. Party number, hey, num didiba. By relying on the said judgment, the respondent states, the counsel for the respondent states that the applicant is the necessary party in proper adjudication of the case. I've heard the counsels and I've gone through the records. But Mr. Singha, this is impleading application was allowed by this court, single bench.
Yes.
But whether I can do it?
Yes, Your Lordship, I'm filing for a recalling of a petition. I'm not appealing against this order. I'm only saying that I'm not a party respondent. That can always be done, Your Lordship.
But I don't know whether this is a judicial propriety will demand.
It's not, you know, Your Lordship, it's not over.
No, recalling by the same judge is okay.
Yes.
But now that he's not there.
Yes, Your Lordship, that can be done, Your Lordship. Otherwise, I would have placed at the very instance. Because this matter was heard by.
What do you say, Mr. Bhattacharya?
I agree to my learned senior because only after that implement, this agency became a party. Only then, after that, the party had
But
the
you could have
opportunity.
challenged it before the appellate court
Your Lordship, this is not.
by filing an writ appeal against the interim order. This is kind of an interim
Striking
order.
off, my lord, is usually allowed, my lord. It is not considered as an over ruling of the earlier order where the implement was
We are not
allowed.
challenging any
Yes.
judgment. We are only saying that we are not necessary party, so we should be striked off or it should be recalled, that order. That is the only thing, Your Lordship.
And that will happen, my lord, post implement because prior to implement, they are not even a party, my lord. So,
Oh, but then I'll have to see. What do you say, Mr. Mishra? At the back, and Mr. Yes.
One of the cases which I appeared for the AG, I prayed for striking of the name of the AG. It was done, my lord.
No, striking of the name of the AG is okay.
because.
But
AG
this
He's
is
referring to
an
my lord
order
accountant
for
general.
impleadment.
AG means accountant
Accountant
general,
general.
office of the accountant general.
As a as a
because
response.
the office was not a necessary or a proper party in the pleading. So I prayed, I made a prayer, my lord. The prayer was allowed, my lord. So striking off can be done, my lord.
But this is again by a single
Because
bench of this.
if your lordship holds that that the party who is seeking his name should be recalled, my lord. If your lordship holds that not, that party is not required for a proper adjudication of the matter, then definitely lordship can pass
But
an order.
no, I can have a different view, but having a different view is different. And then it is challenging the single judge's order.
Whether
And a
that-
single judge's order will pass an order against.
Your lordship, when there is a stay order passed by, the same stay order gets vacated by that single judge.
And
On
in a
vacating
different bench also.
application.
By a different bench also.
No passport.
On a vacating application.
Justice Jamir. But vacating applications are taken by single bench, right?
Yes, your lordship. So that is the same thing. We are not trying to overreach an order of the court. We are not challenging the orders of the court.
Since the honorable judge who passed the order is no longer there in this court, and the matter has been allotted to your lordship, lordship can definitely pass necessary orders. Because it has been allotted to your lordships.
Okay, I'll pass the rest of the judgment in my chamber. I'll just go through once and then I'll pass it.
Otherwise, the
Rest of-
registry would have not raised the matter before your lordship.
Registry does many mistakes, wait.
This application would not have been allowed, your lordship. Because your lordship, this is a recalling of, otherwise also this is simply saying that recalling the order wherein I was implicated as a party respondent where I'm not required to be. It is in the larger interest, your lordship.
No, it's okay. That I understand. But then, same bench, same single bench, one has passed pleading and one will say that not a proper party is not in the judicial propriety
That
of
order
the.
was passed without hearing me, first of all. And then in that order, your lordship, I just placed the impleadment application. In that impleadment application, he has not stated any reason. That these are the reasons why this party must.
No, these are in the merits of the case, but whether it is at all permissible. Okay, I'll just see something and then I'll pass the rest of the order. Okay? Rest of the order, my chamber, do not sign them. Hmm. 30. Yes. I had to dispose of my rest of Jan, I know.
Lordship, the IS will dispose of.
No, that also I will decide. Decide. You'll get to know in a day or two. Yes, 40?
7.
7 years.
May I please, your lordship? Lordship, in this writ petition, basically there are two issues.
Acha, what issues? I'll come later.
Yes.
But why has it been listed for orders today?
Yes, because of the IA that have been filed by me, my lord, for staying the disciplinary proceeding.
Acha, no affidavit in opposition has been received from the respondents till date. Yes, Mr. Kumar?
Yes, your Honor, not yet filed. Your Lordship, we have received a parawise comment. It is given to us on, issued on 7.
In respect of the IA?
Your Lordship, this is in respect of the writ petition.
Acha, IA is for what?
I is for stay of the disciplinary
Staying of the
proceeding.
disciplinary
proceeding.
Before pressing, basically, my lord, in this writ petition, there are two issues. One is for staying of the disciplinary proceeding and one is for reinstatement in service. So, my lord, before, first, I want to praise the reinstatement issue, my lord. So basically,
No, let him file the objection then.
my lord, for reinstatement, I don't think so. Objection would be required. If
Acha, staying of the disciplinary proceeding, you have not prayed in the writ petition.
Yes, sir, that is, their prayer is there.
that is
Prayer
there.
is there.
The main prayer,
Why?
the main prayer is there. I is for still continuance of the writ petition that may be stayed.
That is there in the writ petition also.
Not in the interim, my lord.
Interim order you have not prayed for.
No, that was the difficulty. Therefore, let
Oh,
us
that's why this IA.
And in the motion stage, in the motion order, it was observed that continuance of the disciplinary proceeding will be considered in the next returnable date. That was also an observation, basically.
Acha, otherwise, 2426 order is that PNRD department took 3 weeks time to file their response.
Your Lordship, they
So
sorry.
PNRD department, did they file?
No, not yet filed, Your Lordship. give us 10 days time.
My lord,
Okay.
You
basically,
have the additional AG.
Yes, yes, I'm appealing you.
my lord, basically, I want to press the reinstatement issue first because it covers the Honorable Supreme Court judgment that is Ajay Kumar Chaudhary, my lord.
It's okay, that we will take up. Let them file the counter.
My lord.
Right. So PNRA department, who appears?
Your Lordship, I am appealing.
Oh, you also, you appear.
I am appealing.
Okay, you file an affidavit as soon as possible.
Yes, Your Lordship. 2 weeks time, Your Lordship.
This is. Why there are two applications here?
One is additional affidavit, my lord,
One is additional affidavit.
because subsequently they have issued a speaking order.
Acha.
Not speaking order, it's an order.
I don't know why there are two set of IA here, 169, 169. But additional affidavit is not written.
There is only one IA, my lord, that is listed for today. and
Maybe
there is-
wrongly they have annexed
Yes,
two
might
IA.
be.
This is filed on 21st of January 26.
Yes.
And this is also filed on 21st of January 26. Two copies are given here in one file.
There might be some mistake, because on the same day, I have filed both this additional affidavit and this IA.
Acha, okay, let him file the affidavit.
Yes, yes.
Heard Mr.
BM
what?
Decker.
PM,
BM Decker.
BM Decker, learned counsel for the petitioner, and Mr. K. Kumar, learned additional AG for additional AG, as well as Mr. P. Mishra, Brijesh Sharma, learned for his counsel for respondent number 4. Accountant General. Okay. Mr. Kumar,
I'm appealing for rest of the respondents, Your Lordship.
rest of the respondents.
Yes.
Acha, Mr. Kumar for all the respondents except 4, huh? 1, 2, 3, 5, and 6. State respondents. So Block Development Authority, Jorhat Jila Porikhod. Mr. Kumar submits that he requires some time to file the counter affidavit to the IA.
Your Lordship, the, in the read petition, Your Lordship. I'll file
That will cover.
Hmm?
That will cover all this.
because this was involved in the read petition also. Your Lordship.
Wait, petition, I'll just see whether you have not made. Oh, interim prayer is not made.
Only for
Yes, yes.
time. Your Lordship.
So and so in the IA as well as the writ petition. See
Yeah.
also you say something.
Yes, yes, yes.
IA as well as in the writ petition. Prayer is allowed. Liz, you will also file.
No, my lord, our role is limited to the extent of issuing the pay slip for the suspension period. We have already done that.
So Accountant General has nothing much to say. Only to issue pay slips. Okay, prayer is allowed. List this matter on. When do you want?
28.
28th of May, 2026. Can you file your?
Yes, Your Lord, 2 weeks. 2 weeks time.
2 weeks will be done.
Yes.
Okay, 28th of
Yes.
28th
Before
of
that, they will file the.
May 2026.
Much obliged.
Mhm.
Obliged, Your Lordship.
49 PO. Adjourning. Yes.
May it please your lordship, lordship on the last order, we are directed to take fresh steps, but due to some inadvertent, we could not do it. We have taken.
Oh.
Huh? Yeah.
You will take it in a day or two?
Your lordship, we have taken it today.
Today?
Yes, we have
Acha.
some demo copies.
Acha, okay. So only one respondent?
No, your lordship. 1 to 5.
1 to 5.
Yes, we have some demo copies.
No, to learned, Miss S. Chutia Elementary has accepted on behalf of 1 and 5.
Yes, your lordship.
And 2 also?
3 and 4 we have also submitted.
Serve notice 3 and 4 through P. Nayak.
Yes, your lordship.
So service is done. You have you have not taken steps through P. Nayak.
Today we have given.
Okay. Heard, Miss?
M. Kakoti, your lordship.
M. Kakoti, learned counsel for the petitioner, who submits that in pursuance to the earlier order dated 6/4/2026, which required, by which it was ordered that the petitioner is to take steps for service of notice upon respondent number 3 and 4 through Mr. P. Nayak, Learned Standing Counsel SCRT, within 3 days. However, the said steps was inadvertently could not be taken by the petitioner. As such, time is sought for to take the necessary steps. Prayer is allowed. The petitioner, prayer is allowed for the ends of justice. Prayer is allowed for the ends of justice. Petitioner is directed to take steps for service of notice upon respond number 3 and 4.
Lordship, we have served today.
Oh, you have given the copies to P. Nayak?
Yes, Your Lordship.
আচ্ছা তেতিয়াহ'লে কি কৈছিলো প্ৰেয়াৰ ইজ কিবা ক'লো নহ'ব তাৰ আগত could not be taken and by the petitioner and the learned counsel submits that the said steps were taken today. That is, the copies were given to Mr. P. Nayak, learned counsel. Further, the petitioners sought for some time. List this matter again for orders on, list this matter again on 26th of May. Okay, let Mr. P. Nayak say.
Obliged, Your Lordship.
It will last again. 56 years.
Please,
It went for mediation.
Yes, Lordship.
Failed.
No, Lordship. Both parties have appeared before the mediator and accordingly some report has been submitted in Lordship. As per the report, Lordship may pass an order.
Acha, where is, this is the report.
Yes,
Wait.
Lordship.
The report says as per orders, as the first day for mediation appearance subsequent date could not, only the petitioner appeared that day and subsequently, however, on so and so, all the parties are looking for settlement and read over to the parties for signature. Though all the sides took time to sign the settlement, the petitioner and other rival candidates, claimants amicably agreed to distribute among themselves the retirement benefits of the, as the case may be. Acha, they were given a draft settlement
Yes,
for
Lordship.
signature. Whether the signature is done?
Yes, Lordship.
Signature is done.
Oh.
So no,
Respondent number 4 and 5, my lord.
so no issues now.
Yes,
Yes, yes.
already agreed to the
Already
terms and
some
conditions.
percentage of the pension rate.
And this pension was also distributed among themselves.
Till now, or not.
Will not, according to
Just
order, will
agreed
be.
to the terms
be
and
distributed.
conditions.
The settlement was done between the parties
Mm.
and it was submitted before the mediator. According, mediator submitted report before. the
Yes.
report.
Hmm. So let us wait for what has to be done, or we can close this matter.
Close this matter accordingly, our report of the mediator. you can
If
close-
there is any violation of the mediator's report, then anybody can come,
Yes,
right?
Yes, yes, yes. Yes,
Because
Lordship.
there may be some issues left.
Yes, yes.
Heard Miss
M. Das.
M. Das, learned counsel for the petitioner, and Mr.
A Gayan
A. Gayon for respond number
for 4 and 5.
4 and 5, and Mr.
Thus for U Sharma, for 1 and 3.
1 and 3.
Yes, Lord.
What about others? Oh, Finance Department. Okay. So and so. The instant case was sent for mediation. And the mediator, after hearing all the parties, had passed an order, had submitted a report, passed on, had submitted a report stating inter alia that the parties have agreed for a settlement and a draft settlement was handed over to the parties for signature. it is also stated therein that the petitioner and other claimants amicably agreed to distribute among themselves the retirement benefits of the deceased husband / father, as the case may be. The learned counsel for the parties have stated before this court that the draft settlement has been signed by the parties concerned. By the said report, the mediator has also furnished the mediation settlement agreement between the parties, wherein signatures are seen of both the parties. In view of the same, the instant case is closed with the liberty to the parties concerned to file necessary applications before this court, if any, if any cause of action arises.
Maybe direction may be required to provide the proper, provide the pension to the respondent and also the.
No, the agreement was only to distribute among themselves.
It was not transferred to them. Pension.
No, it will transfer to them in due time when the pension will come. Pension will get submitted in a particular account, then you will distribute what? I don't know.
Yes, ma'am. Yes, ma'am.
That is the procedure. Right, pension will come and get submitted in a particular account of wife
Then
or,
only the distribution will come to place.
then only distribution as per the agreement.
Yes.
Any cause of action arises, then you can come. Matter is disposed of.
Lordship, in respondent number 1 and 3, Lordship, Miss U Sharma's name may be recorded. I am appearing on her behalf.
U Sharma for respondent number 1 and 3. I said so. On behalf of, I've said so. Okay. These are all. I'm blessed. Yes, thank you.